Republic of the Philippines, Court of First Instance of Rizal, 7th Judicial District, Branch 28, Pasay City. Wilson P. Orfanada Plaintiffs vs. Macario Rodriguez and heirs, the heirs of Don Miguel and Hermahines Antonio Rodriguez, Doña Aurora Fabulary Cardona, Patricia Shiangson and heirs, Ponciano Padilla and heirs, Feliman Aguilar and the heirs, Fortunato Santiago and Maria Pantaleona P. Santiago and heirs, Marcus Estanislao and Mauricio de los Santos / Blas and Sebastian Fajardo, Antonio / Eulalia Agua, Don Mariano San Pedro y Esteban, and Maria Socorro Condrado heirs, the heirs of Florencia Rodriguez, Esteban Benitez Tallano, et al., Ingracio San Pedro and heirs, the administrator of Bacatan Market / Masalo Estate, et al., Pedro Gregorio / Agapito Bonson and heirs, Balbino Francisco, Pedro Rogers Estate and heirs, Eugenio Marcelo / Juan Joseph, Santiago Garcia and heirs, Ortigas and Company Partnership, the administrator of Pasay and Triple Estates, and the Miracaban Estate, Perpetua and Perfecto Aquino, et al., Antonio Fiel, the administrator of San Pedro Estate, Jose Salvador / Magno Fernandez / Doña Lourdes Ochoa y Casal, Simona Estate and the heirs, Exequiel de la Cruz and heirs, Hervatio Lombo, Francisco Soriano, Quintin Mejia / Catalina Estanislao and the heirs, Juana Cruz and heirs, Gabino Javier and heirs, the Modesto, Eulalio, Thomas, Apollonio, Pedro, Francisco and Antonio Cruz, Rafael Serror, Jose Oliver and the heirs, the Manada de Campo Bohín, et al., Manuel Quaji, Estanislao, Eduardo and Bernabe Cardozo and the heirs, Antonio Aquil, Page 2, Dr. Nicola Jacinto, et al., Fernando Jacinto Steel Mills Incorporated, Felix and Claudio Osorio and heirs, Regino de la Cruz / Gil Santiago, Bonifacio Regalado and heirs, Marciano Tuazan and Tuazan Company, Julian and Juan Francisco Serrao Motors / Francisco Motors Corporation, Philippine Share Company, Pillar Development Corporation, Teodoro Lim, Felix Bees and heirs, Valentino Gajodo / Candido Cleophas, Fort William McKinley and the Manila Railroad Company, University of the Philippines through Honorable Solicitor General, the Commissioner of Land Registration Commission, the Honorable Director of Bureau of Lands, the Republic of the Philippines, and to all whom it may concern, defendants. Benito A. Tallano, intervener. LRC / civil case number 3957P, for quieting of title / reconveyance of real properties with reconstitution of OCT number T-01-4, TCT number T408 / TCT number T498 in accordance with Republic Act number 26 in the name of Prince Lacan Tagean Tallano, Don Gregorio Madrigal Acop and Don Esteban Benitez Tallano. Decision with compromise agreement. With the blessings of our supreme doing with his judicial enhancement over the victim of injustices and greatest land-grabbing scandals, the Republic of the Philippines failed to deviate from entering with the heirs of Prince Julian Macleod Tallano for a separate decision with compromise agreement, but to settle once and for all the issue of ownership over the land under OCT number T-01-4 together with the reconstitution of lost owner and the duplicate copies of its original was a motion filed by the Republic of the Philippines, and, including the return of precious metals and stones consisting of 617,500 metric tons of gold and 500,000 pieces of 10-carat diamonds to the royal family, is another motion filed by the herein intervener, that needs to be resolved under the same SALA that originally. Page 3, under old case LRC / civil case number 997P but now, on the motion of the Republic of the Philippines, to avoid conflicting of hearing dates of two cases, under the same subject matter, a consolidation of original case LRC / civil case number 997P into LRC / civil case number 3957P has been submitted and impleaded. but we seek the truth and nothing but the truth, that this honorable court has come to intervene where the succor of the magistrate of justice for equity and vindication by the untainted facts, had necessitate this providential circumstances inasmuch as its paramount object to secure the weak, and exalted the victims of oppression for the unmolested true spirit of justice and its virtue for the deserving litigant. Indeed, in the findings of Justinian, instant. B1, 'tis, Co. 2nd instant 56, justice is the constant and perpetual disposition, to render to every man his due. It is a conformity of our actions and our will to the law, but it should be commutative, for which that virtue whose object is to render to every one what belongs to him, as nearly as may be, or that which governs contracts. Yet, justice needs to be distributive as well, that virtue whose object it is to distribute rewards and punishments to each one according to his merit, observing a just proportion, by comparing one person or fact with another, so that neither equal persons have unequal things nor unequal person things equal. Justice, in specific parlance, is the greatest interest of man on earth. It is the ligament that holds civilized nations together, for it consists simply in letting Page 4, everyone enjoy the rights that he has acquired by virtue of the laws. And this must be enforced accordingly in the case at bar, otherwise, justice under this regime is inutile if not dead. Similarly, this remains precarious to our political, social, and economic stability as well, and, in toto, an obstruction to this nation's progress and stability. In a democratic institution, the right to property is a fundamental, natural, inherent, and inalienable right. Clearly, it is never ex gratia from the legislature, rather ex debito from the duly constituted fundamental law of the state, the Constitution. Indeed, it never owed its origin to the Constitution which secured it, for it existed foremost before them. In several circumstances, it characterized judicially as a sacred right, the protection of which is one of the paramount objectives of the government. The constitutionally protected right of private property is not, however, an absolute right, and it is subject to justifiable restraints and mandated regulations instituted by the legislature or ordained by the said fundamental law. It is subject to the police power of the state, and to constitutional order on social justice. Then land reform or equitable distribution of wealth is very good example, when it has been implemented within the tenet of the constitutional policy of the government, because, within that rights, the right to property, is the right to acquire, hold, enjoy, possess, manage, insure and improve said. Page 5. Property, as well as the right to devote property to any lawful use, but it is so defeating to live within this alleged democratic nation, where the present administration capitalizes said glorious objectives, but actually indirectly disenfranchising the constitutional rights of the Tagean Tallano clans from their real properties, by distorting the true record of the royal clan in the LRC, defeating their ownership of the land they gained out of their hard labor and more than 4 centuries of armed struggles against the Spanish government and abusive officials of the Republic, that, only to find out their ownership right over the said property consisting of 169,912,500 hectares of plains, mountains, forests, and seas evidenced by a land tile OCT number T-01-4, Annex A to Annex A1 to A19 that had been issued by the Royal Government of England, through the Office of the Royal Ordinance, then by the British Governor to the Philippines Townsend Rake, is lawful within the bound of the Land Registration Act 496 after the same subject land its ownership had been settled in a court of proper jurisdiction by the Land Registration Court, which was ended on October 3, 1904, under a case CLRO 475, which caused the issuance of Decree 297, and was registered in favor of Raja Lacan Tagean Tallano, who was married to Princess Rowena Maria Elizabeth Overbeck Macleod of Austria, and eventually to their son, Prince Julian Macleod Tallano Tagean, who was married to Princess Amina Kiram of the Sultanate of Sulu, after another court battle in the Cadastral Court in accordance with the law of Cadastral Act 2259, which was, page 6, ended on March 14, 1914, had been promulgated in favor of Prince Julian Macleod Tallano against unlawful claimants, Don Hermogenes Rodriguez and heirs, declaring court ruling in a land registration case number 571 is null and void ab initio, because proceedings under said land registration case 571 had failed to substantiate the jurisdictional requirements and valid jurisprudence. Besides, it was proven that the ownership rights of Don Hermogenes Rodriguez merely derived from fraudulent documents. The lease agreement from the Tagean Tallano clan had been diverted into certificate of award from the Spanish government, yet it can be precluded as valid ownership land title because, long before the Spanish government arrived here in the Philippines, the island had and has been in actual possession of the royal family, through their predecessor in interest, King Louis Ang Tagean. Besides, finally OCT number 01-4 had been issued to the Tagean Tallano clan, not to the Rodriguez due to a conflicting information and evidences they presented using the reward certificate issued by the Spanish government. The alleged court decision dated November 6, 1911 by the Court of First Instance of Manila is a hoax judgment, because it was then the Land Registration Court that has exclusive jurisdiction over the land's registration case, and not the CFI, and that the plan the Rodriguezes had been using could be found in Rojas and Iloilo City, Annex B and C, not in Manila whatsoever. Furthermore, on the sworn manifestation of LRC Administrator Antonio Noblijas, he specifically explained that the title form used in the issuance of alleged OCT 369, page 7, is from the Land Registration Form number 1, yet, in 1907, the year the alleged land title is dated, the so-called GLRO was not yet born for use. It construed the said GLRO form number 1 was not in existence yet. Again, the OCT 369 in the name of Don Hermogenes Rodriguez was being issued by late Judge Estel Rosario as CFI Judge of Wrestle, patently fabricated from the fraudulent OCT issued in the name of Francisco Manahani Torrente, also issued by Judge Estel Rosario as a CLR judge. And that the alleged CLR case number 386, Manila, divulged that the decree issued was decree number 160, not decree 297, because decree 160 was issued on March 19, 1904, and not March 8, 1907. That under the said CLR case number 386, decree 160 was OCT number 140, not OCT 369, was issued in the Registry of Deeds in Manila. It covers only one parcel of land located in Tondo, Manila, with an area of 354.03 square meters. On the part of OCT number 01-4, with decree 297, CLR case number 475, the same were issued in the name of Prince Lacan Acuna Tagean Tallano on October 3, 1904, after compliance of the LRA 496 requirements embracing the whole archipelago, but was fraudulently deleted and distorted over the landing cavity alone instead of the whole island, as could be found in Record Book of Decree, Book 1, and was distorted in the name of Manuel Ruzi Javier instead lawfully to Prince Julian Macleod Tallano. That the alleged plan number 11-4810, covering 3 parcels of land in the municipality of Sagay, Negros Occidental, not in Sandianicio and Ebeo, Paranaque, Nicholas Byans and Laura Ana Vargas were applicants. Page 8, while that plan 2-4812 covered a parcel of land situated in Berrio Tinampan, Cadiz, Negros Occidental, not in Paranaque, province of Rizal, while that plan's 2-4813 was merely inserted as part of the plan in CLR case 9002, and said parcel of land consists of 3,807 square meters situated in Colsmart, municipality of Iloilo, and was surveyed by G. and M. Mendez, LRC Administrator, attested in his sworn affidavit and manifestation that all 2-4810, 2-4811, 2-4812 and 2-4813 found no existing survey record in the Record Management Division of the Bureau of Lands and Forestry. This court has observed the blueprint pattern of clandestine land grabbing by the alleged claiming to be landowners, which were derived from the national government through its instrumental agencies, the Bureau of Lands and Forestry, the Land Registration Commissioning Conspiracy of the officials of Building Permit Bureau of the Department of Public Work and Highway, and by the local government officials, and with participation of some Register of Deeds in the city and provinces where the lands are situated. These are where the sacred role of the government must have to be exercised for the protection of the constitutional rights of its citizenry. Yet, very clearly, that land grabbing scheme massively laundered icing by socialized housing programs, urban and agricultural land reform of the government in connivance with the developers, sometimes in the pretext of national government infrastructure program, is a silent confiscation of real properties of the private. Page 9. Persons, particularly to the damage of the Tagean Tallano family who lawfully own the vast of land here in Greater Manila area suburbs. By these circumstances where the national government arrogantly launched its clandestine confiscation of private properties, movable and immovable, it is hard to admit that there has no violation of due process. Actually, violation of it is presently in serious offense of the national government for grand design of its cohort depriving the constitutional mandate of Section 1 and Section 2 of Article 3 of our 1935 Constitution, directly defeating the real substance of due process here, namely, 1. To prevent improper governmental encroachment against an individual's life, liberty, and property. 2. To prevent arbitrary exercise of government powers. 3. To prevent unjustified confiscation of private property. Our great Senator Diacono eloquently explained the relevant objects of due process, quote, "The requirement must be directly intended to have the same effect against legislative power, that is, to secure the citizens against arbitrary deprivation of his constitutional right, whether relevant to his life, his liberty, or his property. It is an absolute limitation toward arbitrary power and a guarantee against abusive legislation requiring that the law shall not be unreasonable, arbitrary, or capricious in character and or objective should have a real Page 10. Substantial purpose and effect to the object sought to be attained. The supreme intention of the guarantee is the protection of the individual from the arbitrary implementation and execution of powers of the government, undisturbed and with genuine established principles of private rights and distributive justice." Unquote. Our great senator lent his judicial wisdom relevant to this proceedings, where coercive influence from the authority had intended to inflict against the true essence of justice, particularly in the case at bar where substantial evidence is of the heir of the late Prince Julian Macleod Tallano backing up their ownership interest over the subject land, and has been meritoriously adopted from the national government evidences and position paper. Could not be subsided by technical maneuver of the Solicitor General, and, obviously, by mixed influence of the executive order, proclamation, and letter of instructions, allowing its cohort developer, specifically private development corporations of the Philippines who bulldozed the big tract of land both the north and south of Manila for the proposed expressway, where thousands of mango trees were uprooted and destroyed, the Pillar Village Corporation who massively bulldozed portion of Quezon City where the 10,000s of mango trees were destroyed for the government pretext housing projects, which said projects of the Pillar Village Corporation could be magnified almost in Greater Manila area, and that the Malacanang Palace official conspirator, certain Bonifacio Regalado who arrogantly bulldozed big tract of land on the east, north, and west. Page 11 portion of Quezon City, where thousands of mango trees were destroyed, and that its cohort Manny Villa and Company Real Estate proposed housing projects in Muntinlupa, Taguig, Paranaque and Las Piñas, where 500,000 mango trees were bulldozed and destroyed. Then the direct cohort and oligarch real estate developers of the higher officials of the palace, the Ortigas and Company, who raped the original view of San Juan, leaving destroyed thousands of mango trees simply to be replaced by the proposed shopping center and executive village in the said Green Hills, depriving the interest of the late Don Juan Ejercito and his heirs, that Harry Stonehill mess who conspired with some Malacanang officials before, who destroyed 500,000 of mango trees in San Pedro, Laguna only for the elite housing projects, and who attempted for the restoration of the war-widely damaged Manila Bay for self-interest of the landowner, the Tagean Tallano family, and the Malacanang cohort's oligarch developers in Marikina, who attempted to land grab some 1,500 hectares of land situated in Paraning, Marikina, res alone by the family of Doña Lourdes Tuas and Arroyo, who bought from the real owner, Don Esteban Tallano, close friend of ex-President Diosdado Macapagal, and particularly that Ayala Corporation who arbitrarily developed the Forbes Park and the Bel Air Village. in Makati, as aforementioned above, direct denial of due process, awarding the lands to these developers without the mercy of the impartial judge. Page 12. Mr. Justice OCP Laurel must have condemned the conspirators in the government, if ever he has been living as Chief Justice of the Supreme Court up to this time. Because he once said that if accused is not tried by an impartial judge, the pledge of due process becomes a myth and the trial is reduced to nothing but a useless formality, an idle ceremony. Mr. Justice Laurel continued, if a judge had made up his mind to convict, even innocence would not suffice as a defense. Unquote. Similarly, the Moro court proceedings in this cellar under LRC/civil case number 997P against Don Esteban Benitez Tallano and Prince Lacan Acuna Tagean Tallano, the living heir of the late Prince Julian Macleod Tallano, contemplated by some government officials in the Lacan conspiracy of these developers who managed the validation of their fictitious land titles particularly. This OCT 333 of Bonifacio Regalado, its decree number 1141, has been found covering land in Florida Blanca, the OCT 735 of Don Mariano Severino Tuazon, and that OCT 632 owned by Eulalio Ragua, that OCT 730 owned by Peter Distate, that OCT 614. OCT 333, OCT 291, and that OCT 820 owned by Patricia Shiongson, and by the national government, and all OCT its numbers from OCT number 100,000 had been declared non-bankable due to their fraudulent characteristics, and null and void ab initio by my predecessor in this court on July 14, 1964 by virtue of the petition filed by the Republic of the Philippines in favor of its alleged predecessor, late Prince Lacan Tagean Tallano under LRC civil case number 997, which was consolidated to LRC/civil case number 3957P for separate. Page 13. Judgment re-reconstitution of OCT number 01-4 in the name of Prince Lacan Tagean Tallano with annulment of OCT number 01 up to OCT number 100,000 versus Hermahines Rodriguez, from which the petitioner, Republic of the Philippines, had acquired its interest and rights over the subject lands. Under the principles of public domain, alleging in that petition that late Julian Macleod Tallano and Prince Lacan Acuna Tagean Tallano have no surviving heirs whosoever, so therefore, under the law, said big tracts of lands, the Hacienda Filipina evidenced by OCT number T-01-4 be reverted to the national government. On the above proceedings, the constitutional rights of the heirs of the true owner had always been deprived, thanks to the sound meritorious judicial procedure of our judiciary then that asserted by then Solicitor General Felix Macleod, now, the pillar of our Supreme Court, who sent summons and subpoenas to the Tallano Tagean heirs in Hawaii and the old residents of the Tallano Tagean in Sitio Soayo, Barangay Quiliot, Quezon City, the decision in favor of the Republic of the Philippines under LRC/civil case number 997P consolidated with LRC/civil case number 3957P had been reverted in favor of Don Esteban Benitez Tallano by way of opposition paper with supported evidences adopted from government position paper and proof of ownership over the land and proof of heirship to the late Prince Julian Macleod Tallano and Prince Lacan Acuna Tagean Tallano and intervention by Benito A. Tallano, that had submitted during the hearing prior to the release of decision of July 14. Page 14, 1964, which caused this case under LRC/civil case number 3957P as consolidated one railroaded up to this proceedings. On the part of the national government represented by then Macapagal administration, they came to the stipulation for the issuance of the decision with compromise agreement subject to the following terms and conditions, here to wit. 1. That the Republic of the Philippines through its President His Excellency Dr. Estado Macapagal waived its rights over the lands that are still found public lands, all and that have land title including their rights in Crisostomo estate in the city of Cabanatuan, yet and if ever titled only those lands that have fraudulent land titles be reconveyed to and in favor of the heirs of Prince Julian Macleod Tallano. provided the land reform should be respected, maintaining the land emancipated in favor of the farmer beneficiaries. Otherwise, conversion of the land covered by a land reform into a commercial purpose is destroying the aims of land reform. Automatically the ownership interest of the subject land should be reversed in favor of the heirs of the true owner, late Prince Julian Macleod Tallano, Don Esteban Benitez Tallano, or their successor in interest. 2. That the government buying price of the subject land to the Tagean Tallano royal family in case of expropriation by the government should be subject to the following quotations. Page 15. 1. Within the Greater Manila area, a prime lot and commercial lot dash at P 400.00 per square meter, a minimum of 1,000 hectares. 2. For the provinces of Rizal, Laguna, Cavite, Batangas and Bulacan, commercial/prime lot dash at P 350.00 per square meter for a minimum of 2,000 hectares. B. Agricultural land dash at a price of P 10.00 per square meter for a maximum of 100,000 hectares of land area, and succeeding land area at a price of P 5.00 per square meter. 3. For the provinces in Central Luzon, a commercial/prime lot dash at a price of P 230.00 per square meter for a maximum of 2,000 hectares. 4. For the provinces in Ilocos region including La Union province. A. Commercial/prime lot dash at a price of P 230.00 per square meter for a maximum of 2,000 hectares. B. Agricultural land dash at a price of P 5.00 per square meter to a maximum of 10,000 hectares. Page 16. 5. For the provinces of Mountain Province region Ifugao and Nueva Vizcaya. A. Prime/commercial lot dash P 230.00 per square meter for a maximum of 2,000 hectares. B. Agricultural land dash at a price of P 3.00 per square meter for a maximum of 200,000 hectares. C. Baguio City. A. Residential area dash at a price of P 100.00 per square meter for a maximum of 2,000 hectares. B. Commercial dash at a price of P 500.00 per square meter for a maximum area of 2,000 hectares. 6. For the provinces of Northern Luzon, Isabella, Cagayan and Batanes, A. Prime lot dash at a price of P 30.00 per square meter at a maximum area of 2,000 hectares. B. Agricultural land dash at a price of P 5.00 per square meter for a maximum land area of 500,000 hectares. Page 17. 7. For the provinces of Southern Tagalog, Quezon, Sub-Province of Aurora, Sub-Province of Quirino except Mindoro, Palawan, and Bicol regions. A. Prime/commercial lot dash at a price of P 220.00 per square meter at a maximum area of 2,000 hectares. B. Agricultural land dash at a price of P 3.00 per square meter for a maximum land area of 200,000 hectares. C. For the province of Mindoro. A. Prime/commercial lot dash P 250.00 per square meter for a maximum of 2,000 hectares. B. Agricultural land dash at a price of P 5.00 per square meter for a maximum of 2,000 hectares. D. For the province of Palawan. A. Prime/commercial lot dash P 300.00 per square meter for a maximum of 2,000 hectares. B. Agricultural land dash at a price of P 3.00 per square meter for a maximum of 200,000 hectares. E. For the Bicol region. A. Prime/commercial lot dash P 200.00 per square meter. B. Agricultural land dash at a price of P 3.00 per square meter, a maximum. Page 18. Of 300,000 hectares. 8. For the provinces of Visayas. A. Prime/commercial lot dash at a price of P 300.00 per square meter at a maximum area of 10,000 hectares. B. Agricultural land dash at a price of P 5.00 per square meter for a maximum land area of 300,000 hectares. 9th. for the Mindanao area except Jalo, Sulu, and Cotabato, which was conveyed by Prince Julian Macleod Tallano to the three major sultans of Mindanao exclusively for the Muslim brothers. A. Prime/commercial lot P 250.00 per square meter for a maximum of 3,000 hectares. B. Agricultural land at a price of P 3.00 per square meter for a maximum of 200,000 hectares. 3. That the gold bullion lent by the royal family to the Republic of the Philippines, consisting of 650,00 metric tons now, through Reverend Father Jose Antonio Diaz by arrangement of the young brilliant lawyer, attorney Ferdinand D. Marcus in the year 1949, for the establishment of the required gold reserves of the newly installed Central Bank of the Philippines should be maintained to the central bank vaults toward maintenance of the country's gold reserves, and the same should be. Page 19. Withdrawable 50 years thereafter with 5 years moratorium, to stabilize the Philippine peso value, while the clans, the royal family should only be entitled for 5% of the 1% of the appraised value of the commodities as royalty fee, and should be paid by the government in cash equivalent to the surviving beneficiaries. The heir of the late Prince Lacan Acuna Tagean Tallano, who stayed in Vatican from the year 1866 to 1898 where he died at the age 178 years old, survived by his son, the late Prince Julian Macleod Tallano at the age of 50, who was born on December 17, 1848. 4. That said 50 years gold reserve requirement could only be withdrawn by the heir, Don Esteban Benitez Tallano, or his successor in interest, Prince Julian Morden Tallano on the year 2005, after another 5 years moratorium starting of year 2000, provided no among the gold deposits should have been diminished, otherwise, the royal clan represented by their heir, Don Esteban Benitez Tallano, or by his predecessor in interest, Julian Morden Tallano, who inherited lawfully the title of prince under the Code of K.O.R.A.N from his great-great-grandfather, late Prince Julian Macleod Tallano Tagean, has an option to terminate the gold deposits earlier for the interest of the Filipino people. 5. That any gold bullion that was deposited by Senate President Ferdinand D. Marcos outside the Philippine jurisdiction in conspiracy of the royal clan Tagean. Page 20. Administrator, in the person of Reverend Father Jose Antonio Diaz beyond the consent of the owner should be returned back to the Philippine Central Bank vaults. To view actually over the proposed conditions of the Macapagal administration then for absolute implementation has gained some opposition of the present government administration due to the following allegations, although the true beneficiaries had never filed their objections, here namely that the said 640,000 metric tons of gold nuggets owned by the royal family transported by then surviving son of the late Prince Julian Macleod Tallano from Vatican after the World War, in the person of Don Esteban Benitez Tallano through the efforts of Reverend Father Jose Antonio Diaz, trustee of the royal family, and, at the same time client of then attorney Ferdinand D. Marcos, deserves a just compensation to Marcos' client, Reverend Father Jose Antonio Diaz for no less than 30% of the total value of the said 640,000 metric tons, which includes those bullion actually deposited to the central bank vaults consisting of 7,000 metric tons. Besides, there are some proposed amendments over the conditions set forth by the Macapagal administration, which supplements the proposed conditions of then Macapagal administration, as follows. Page 21. 1. That the proposed Lungsod Silangan embracing around 46,000 hectares in Antipolo, San Mateo, Montalban, San Jose del Monte, Tete, Morong, Beris, Estrella, Parit, Alilia, Jalajala, Infanta, Naca, and Real should be paid only to the lawful beneficiary, Don Esteban Benitez Tallano, or to his successor in interest, Prince Julian Morden Tallano at P 5.00 per square meter payable in 1 year in 4 equal installments, provided the would-be registered vendee should be the daughter of the president, Miss Amiroma Aldez Marcos, considering the payment that will be sourced is from the private funder in the United States, a businessman counterpart of the Araneta family too. Secondly, that the land reform program of the present administration should be maintained by the landowner, except the land's already under payment of the land bank, but the value of the land acquired through the land bank financing facility should be paid in cash to the landowner, Don Esteban Benitez Tallano, or to his successor in interest, Prince Julian Morden Tallano, at a price of P0.50 per square meter or at P5,000 per hectare on 5 years quarterly installments. 3. That the mining and marine resources and all resources that may be found above and below the Philippine soils should fall within the ambit and regulations of the relevant laws, particularly the forest and mining laws and fishery laws. Page 22. Ordinances of both national and local governments, but not to the extent of depriving the absolute ownership interest and privileges of the landowner. 4. That the land that has been awarded in favor of the farmers by virtue of land reform program should be well respected, except when the land holdings of the farmers' interest for conversion and those of agricultural purposes, the landowner have the absolute right to recall the land subjected into land reform, to protect the interest of the farmer beneficiaries. 5. That the national government through the Marcos administration had waived its interest over all public lands, which are found untitled, including mountains, forests, rivers, and seas, except when the subject land has a valid land title. Then the landowner should be admitted such valid land title is an act of government under principles of public domain, yet no required appropriation neither penalty should be shouldered by the administration or the succeeding administration in favor of the landowner, except when the land is covered by defective land titles and or relevant document the government administration has deemed reverted to the land and its interest to the Tagean Tallano clans. 6. That all the land occupied by the government buildings and infrastructures, local or national, including those hospitals, capitals, city hall. Page 23. Municipal halls, dams should be maintained to the national and local government in the name of the people of the Philippines, except on the conditions that any said structures that would be subjected reversion, conversion, or sale to other parties defeating the principle of public domain and either defeating the Filipino people's interest as beneficiaries in interest, the same structure, its title and interest be reverted to the true owner, Don Esteban Benitez Tallano, or his successor in interest. But these conditions have limits on public markets and public males, that the direct taxes have been remitted to the national or local government, yet both national or local government including private market operator should pay the landowner for the required rental of P500.00 per square meter monthly. Finally, for the interest of justice, both proposed conditions of the past Macleod administration, which were represented by Honorable Secretary of Justice Salvador Mirano, and then His Excellency President Estado Macleod, and now the Marcos administration and His Honorable Solicitor General, with the conformity of the heirs, Don Esteban Benitez Tallano and his great-great-grandson, Prince Julian Morden Tallano, had refined into a joint stipulation on the purpose of the urgent motion requiring this court for the issuance of decision with compromise agreement, exempting it from the required 5 years prescription period to execute the same, considering the land tax requirements. Page 24, amounting to P250 million.00 as assessed, becomes a prerequisite prior to the issuance of the reconstituted land title number T-01-4, which is indispensable in the absence of amelioration tax and other relative realty taxes. That the conditions that had been agreed upon by the parties, the national government represented by His Excellency Ferdinand E. Marcos by Honorable Solicitor General, and by the heirs of the landowner, represented by retired Judge Cesar Parras, adapting some of the proposed conditions of the present and past administration are as follows. On the part of the national government represented by its past administration, then His Excellency President Estado Macleod and Ex-Secretary of Justice Salvador Mirano, now, by His Excellency President Ferdinand E. Marcos and his council, Honorable Solicitor General, the proposed admitted conditions are as follows. 1. That the Republic of the Philippines through its then President, His Excellency Estado Macleod, along with his then Honorable Secretary of Justice Salvador Mirano, and now had adopted by His Excellency Ferdinand E. Marcos along his Honorable Solicitor General, representing as legal counsel of the Republic of the Philippines, waived its rights over the land that has been presently found public land, or titled land but from fraudulent or fraudulent in character to and in favor of the heir of the late Prince Julian Macleod Tallano, or to his heir of his successor in interest, Prince Julian. Page 25, Morden Tallano, on the conditions that the land emancipated to the farmers' beneficiaries of the government land reform program should be recognized and well respected, free from any taint or maneuver of illegality or conversion of any party whatsoever into commercial or other purposes than the objectives of the land reform program, the said subject land, otherwise in case of breach over the conditions, should be recalled to and in favor of the owner, Tagean Tallano clan, to secure the interest of the Filipino farmer beneficiaries. 2. That the government buying price of the subject land from the Tagean Tallano family should be subjected to the following quotations, hereunder. 1. Within the Greater Manila area, a residential lot dash at a price of P1000.00 per square meter for a maximum of 10,000 hectares. B. Commercial lot dash P1500.00 per square meter for a maximum of 5,000 hectares. 2. For the provinces of Rizal, Laguna, Cavite, Batangas, and Bulacan, a residential lot dash P100.00 per square meter for a maximum of 10,000 hectares. B. Commercial lot dash P2000.00 per square meter for a maximum of 10,000 hectares. Page 26. C. Agricultural land dash P10.00 per square meter for a maximum of 500,000 hectares. 3. For the provinces in central Luzon including Pangasinan, a residential lot dash P70.00 per square meter for a maximum of 50,000 hectares. B. Commercial lot dash P1500.00 per square meter for a maximum of 10,000 hectares. C. Agricultural land dash P5.00 per square meter for a maximum of 500,000 hectares. 4. For the province of Ilocos region including La Union, a residential lot dash P70.00 per square meter for a maximum of 10,000 hectares. B. Commercial lot dash P1200.00 per square meter for a maximum of 10,000 hectares. C. Agricultural land dash P5.00 per square meter for a maximum land area of 10,000 hectares per province. 5. For the provinces of Mountain Province region including Kalinga, Ifugao, and Nueva Vizcaya, a residential lot dash at a price of P30.00 per square meter for a maximum of 10,000 hectares for the whole region. Page 27. B. Commercial lot dash P1000.00 per square meter for a maximum of 10,000 hectares for the whole region. C. Agricultural land dash at a price of P3.00 per square meter for a maximum of 10,000 hectares per province. D. Baguio City, a residential dash at a price of P100.00 per square meter for a maximum of 2,000 hectares. B. Commercial lot dash at a price of P1000.00 per square meter for a maximum of 10,000 hectares. 6. For the provinces of Northern Luzon region including Isabella, Cagayan, and Batanes, a residential lot dash P50.00 per square meter for a maximum of 10,000 hectares. B. Commercial lot dash P750.00 per square meter for a maximum of 10,000 hectares. C. Agricultural land dash P3.00 per square meter for a maximum of 500,000 hectares. 7. For the provinces of Southern Tagalog, Quezon, Sub-Province of Aurora, Sub-Province of Quirino, a residential lot dash P200.00 per square meter for a maximum of 10,000 hectares. Page 28. B. Commercial lot dash P1000.00 per square meter for a maximum of 10,000 hectares. C. Agricultural land dash P3.00 per square meter for a maximum of 200,000 hectares. D. For the province of Mindoro, a commercial lot dash at a price of P700.00 per square meter for a maximum of 10,000 hectares. B. Residential lot dash at a price of P50.00 per square meter for a maximum of 10,000 hectares. C. Agricultural land at a price of P3.00 per square meter for a maximum of 300,000 hectares. E. For the province of Bicol and Batangas, A. Commercial lot at a price of P500,000 per square meter for a maximum of 10,000 hectares. B. Residential lot at a price of P40.00 per square meter for a maximum of 25,000 hectares. C. Agricultural land at a price of P3.00 per square meter for a maximum of 300,000 hectares. Page 29. F. For the province of Palawan, A. Commercial lot at a price of P500.00 per square meter for a maximum of 5,000 hectares. B. Residential lot at a price of P50.00 per square meter for a maximum of 5,000 hectares. C. Agricultural land at a price of P2.00 per square meter for a maximum of 200,000 hectares. 8. For the provinces in Visayas, A. Commercial lot. First class town P1000.00 per square meter, second class town P700.00 per square meter, third class town P500.00 per square meter for a maximum of 10,000 hectares. B. Residential lot. First class town P500.00 per square meter, second class town P200.00 per square meter, third class town P100.00 per square meter, for a maximum of 200,000 hectares. C. Agricultural land at a price of P5.00 per square meter for a maximum of 300,000 hectares. Page 30. Besides, as furtherly claimed by the government in its position papers, there were frauds in the issuance of OCT number 369, OCT 222, OCT 614, OCT 543, OCT 333, OCT 777, OCT 730, OCT 735, OCT 466, OCT 820, OCT 4136, OCT 56, OCT 684, OCT 4080, OCT 994, OCT 4085, OCT 632, OCT 339, OCT 564, OCT 393, OCT 291, OCT 160, OCT 844, OCT 847, and obviously from OCT 02 to OCT 100,000, which we declared null and void ab initio, and thereafter these were cancelled by this court on the motion of the Republic of the Philippines, represented by its Solicitor General Felix Macleod, except that of OCT 01-4, against the unlawful owners, Don Mariano San Pedro Esteban, de Manada de Ocampo, Ortigas & Co., who used OCT 735, the alleged Ponciano Tamayo, Bonifacio Regalado, who used OCT 333, Donia Patricia Shiangson, who used OCT 820, Jose Dimsum, Julian and Juan Francisco, Pillar Village Development Corporation, Valentino Gajudo, Candido Cleophas, Fort William McKinley, Manila Railroad Co., the University of the Philippines, who used OCT 735, OCT 730, Honorable Mefelimon Aguilar, Ponciano Padilla, Antonio and Eulalio Ragua, Maria Socorro Condrado Heirs, the Peda estate owner, Pedro Gregorio Agapito Bonson, who used OCT 4085, Don Pedro Rojas, the alleged claimant of the Miracaban estate, Ricardo and Fortunato Santiago, Perpetua and Perfecto Aquino, Antonio Ville, Donia Lourdes Ocho y Casal, the administrator alleged claimant of the Colegio de San Jose, Mariano Severo Tuazan and Tuazan Company, Teodoro Limon Felix B's, the Republic of the Philippines and its agencies, who used OCT 291, and at certain Nicola Jacinto, whose application is merely free patent in character, must be subsided by Torrens title, the Bureau of Lands and Forestry, the land registration. Page 31. Commission and its Honorable Solicitor General, Hermogenes A. Rodriguez and Don Miguel Rodriguez, who used OCT 369, which claims by the Honorable Solicitor General Felix Macleod, are strongly defeated by well-accepted history and documentary evidences against these land grabbers, but that the said lands had been a subject of land grabbing schemes through forced dominion. An invasion of the Spaniards over the archipelago against the inhabitants, who own the subject lands, embracing the entire archipelago, arrogantly instituted by the friars in the island of Manila instead of Christianism, which was originally known some 400 years ago as Island of Mahalaca, which said land grabbing, were escalated through frauds, by mentioned alleged fictitious landowners. Now the entire island known as Philippines, where the inhabitants suffered thousands of casualties in the midst of bloody war against said Spanish soldiers land grabbers. Yet, the Honorable Solicitor General claims as their defense that restoration of inhabitants' rights over the patrimonial lands was the efforts of the government of the First Republic. Therefore, said land should be reverted to the government under the principle of eminent domain. The manifestation of the government was controverted ostensibly by the herein interveners, by presenting documentary evidences released by the newly recognized Philippine Historical Commission together with their evidences, found in their possession here, namely Annex A4, certification from said government agency dated January 10, 1964. Confirming the claim of the interveners, that the entire Greater Manila area was under the territories of the Namayan then some 5 centuries ago, which, page 32, was divided into 7 districts of Maycatman, Calatandanan, Dangas, Dilor, Pinacazan, Yamagtugan up to Misapan, whose territories, based on said documents, are those now occupied by the town of Pasay, Malati, Dilor, Pandacan, San Felipe or Mandaluyong, Balito the San Juan del Monte, Quiapo, Sampaloc, San Miguel, Tete, San Pedro de Macati now Macati, Navatas, Malaban, K.O.R.A.N Mesalo before, Caloocan, Valenquilla or Valenzuela, Quezon City or Pugadloin, Montalban, San Mateo, San Jose del Monte Bulacan, Marikina, Santa Maria, Angat Bulacan, Norzagare, Bulacan, Tanay, and Tapalo, Morong, a former provincial capital in lieu of the province of Rizal, Cardona, Quilele or Cainta, Angono, Palila, Jala, Beris, Teresa, and the Kiril Islands now Quezon Province, which includes the whole Cornet region now Cavite and that lake region in its new name, Laguna Province, including portion of Batangas Bamban Province before. Laurel, Talisay, Lemery, Tal, Nasugbu, and Lipa, where the origin of its inhabitants came from the noble family names Lacan Tagean, the Datu or the Mahalaca and grandson of the King Luisang Tagean centuries ago, and by his wife Lamayan Bowen. The noble tribes were the owners of the said territories and they control the areas, and inhabit themselves over the areas for more than 5 centuries ago, and it has passed by more than 10 generations of their clans. Some of these were their children in the name of Raja Lacan Tagean, the 11th son of Raja Soliman, who led bloody strikes in Manila against the Spaniards during the Spanish time, while in Cebu led by Raja Lapu-Lapu, older brother of Raja Soliman, the leader King Luisang Tagean. Page 33, and his sons Raja Soliman and Raja Lapu-Lapu and Raja Lacan Tagean, eldest son of Raja Soliman, are of Malayan blood, born from known Malayan Federated Estate, were migrated to Manila Island due to the cataclysmic evolution of the earth that affected man's habitation, while the wife of Raja Lacan Tagean, Lamayan Bowen, was forced to migrate to the coastal area of Santa Ana now Lamayan district before, where Lamayan name was derived from her maiden name baptized to her tribe, where Lacan Gajuban Morben, younger son of Raja Soliman, born along the northeastern part of Sierra Madre, and is known hero of the town of Morben. In the advent of Spanish era in the island of Manila more than 400 years ago, the Lacan Tagean clan, the grandson of King Luisang Tagean, eldest son of Raja Soliman, was renamed into a Spanish sound name, Tallano, to be elusive every time from the Spanish government prosecution and inhumane torturing decide to take advantage the arrest and court immunities granted by the Royal Crown of Spain to Filipino mestizo and to Spanish nationals. The effort gained momentum from Spanish authorities, although in clandestine operation, the Tagean clans pursued their endless support toward the Filipino Revolution by armed struggle, morally and financially pushing throughout the archipelago against Spanish despotic autocracy, until it borne out by them the Macleod revolting Cagayan. Raja Solomon, the father of Lacan Tagean in 1571, led a successful revolt in Manila, followed suit and many more arms uprising at the expense of their own effort, precious stones and precious metals like gold jewelries which they used for the rebellion against Spanish government as a. Page 34. Tagean clans saved out of their 1,000 years habitation on the surface of the earth, particularly in the island of Mahalaca, now Philippines. Later, during the Spanish era, they called the islands as Manila as they extracted from medicinal shrubs named nilad for which they defend the land they built, and acquired through manual labors of their ancestors some 1,000 years with the help of their creator and our Mother Nature. Again, for reference, Manila started some 1,000 years ago, even before it born out from the very womb of Rio de Tagean Pasig. Certainly, it was an integral portion of the cataclysmic evolution of the Earth plate. The origin of Manila name is undoubtedly old. It was derived from medicinal shrub named nilad, in English name Scyphiphora hydrophyllacea, which was usually used as medicine for the wounded Tagean warriors long before the Spanish time. But, originally, the seat of the most powerful Datu, the King Luasan Tagean, which was inherited by his son, Raja Solomon, and later by his grandson, Lacan Tagean, was not in Manila, but in Lamayan district, now the place of Malacanang Palace, previously a district of Santa Rona where the Lacan and his royal family reside. The evolution of the Tagean clan into Tallano clan served as catalyst in pursuing their claims and interest in land against the Spanish government until such time when foreign intervention, like the British royal government which started in 1761, had successfully liberated the Filipino people from the Spanish colonization on October 14, 1764. While the American government took its noble role and settled the inhabitants' perennial land problem by Page 35, Cessation Treaty that caused the Spanish-British government worked for the said peace accord over dominion in the Philippine territory, and had been taken in place successfully in the acquisition, cost of $5 million US dollars paid, and extended by the British government, but such amount had provided by the Tallano Tagean clan through the king's son, Prince Lacan Tagean Tallano, who was born on December 17, 1686, the grandfather of John T. Macleod, on the condition and the said accord, the British and the Spanish governments and the US government as well, and any foreign dominion should respect the inhabitants' private ownership and interest in land. As a result of this treaty, and another treaty, the Treaty of Paris, had come out into being, yet, respecting the precondition that private ownership and interests in lands in the Philippines should be exercised with virtue undoubtedly. Treaty of Paris between the United States and Royal Crown of Spain, Article 8, second paragraph, dated April 24, 1894. To wit, and it is hereby declared, that relinquishment or cessation as the case may be, to which the preceding paragraph refers, cannot, in any respect, impair the property rights which, by law, belong to the peaceful possession of property of all kinds. Of province, of municipalities, public or private establishment, ecclesiastical or civic bodies, or any other associations having legal capacity to acquire or possess property in the aforesaid territories, renounced or ceded to private individuals of whatsoever nationally such individual as they may be. Page 36. The aforesaid relinquishment or cessation as the case may be, includes all documents exclusively referring to the sovereignty relinquished or ceded that may exist in the archives of the peninsula, where any document in such archives only, in part related to said sovereignty, a copy of such part will be furnished, whenever it shall be requested. Like rules shall reciprocally in favor of Spain in respect to documents in the archives of the island above referred to. Article 9. Spanish subjects, natives of peninsula residing in territory over which Spain, by the present treaty, relinquishes or cedes its sovereignty, may remove therefrom, retaining in neither even all rights or property including the right to sell, or dispose of such property, or of its proceeds, and they shall also have right to carry on their industry, commerce, or profession, being subject in respect thereof to such laws as are applicable to other foreigners, dated April 25, 1894. Unquote. very clearly, as a matter of right in the Philippines, prescribed by such Treaty of Paris, in preservation of private ownership over the land, through the English theory found a closer importance. That furtherly, during the domination of this nation by Spain, the royal crown spared no time nor any odd to proclaim full ownership totally over our lands, that private land titles from the very origin could only be possessed from the government. Page 37, either by buying with granting the titulo de comprar by bidding, or by different modes of acquiring it all and grant. But the most exception to this cardinal rule was where certain person had established his ownership over the land he is claiming, or through his predecessors in interest, and had been in possession of the land from time immemorial, and such possession would mean justify the presumption that the said land had been a private land even before the Spanish dominion, controverting lawfully that there is no friar land in the Philippines. Definitely, there is no friar land indeed, while certainly, said allegation that there is a friar land was merely a hoax, just to subside over said land ownership of the royal clans, like the interveners in particular. Yet, furtherly, as part of negotiation, and immediately upon signing of the said treaty, a directive from the royal crown of Spain to the claimants of the land in question, Don Hermogenes and Don Miguel A. Rodriguez, had been sent, and became supplemental to the recovery of the subject by the Tagean Tallanos, certainly over the Hacienda Quebaga together with that Hacienda Filipina. This excerpt directly from the letter of the Queen of Spain in the United States government, quote, being an intruder of the island of Manila, formerly Hacienda Filipina now Philippines, in honor of his royal crown, the King of Spain, you are commanded to be ceased, and desist and reconvey from your land holdings the whole Hacienda Filipina, the archipelago, titled OCT number T-01-4 in the name of Prince Lacan Acuna Tagean Tallano, or to his son Prince Julian Macleod Tallano, the grandson of Alfred Dent, a British lord and London merchant, a par owner of Royal British North. Page 38, Borneo Company, which had been adversed by your interest, and in the name of your brother, Don Miguel Antonio Rodriguez, for so long, to the damage of the true owners. Now, you should respect this royal order in favor of the original landowner, the late King Louis Tagean clan and heirs, the prime predecessors in interest, the Tallano clan, where their rights over the subject lands had been defeated by more than 400 years of our royal army occupation. But said rights are among the preconditions embodied in our cessation treaty with the British government, and with the American government, clarifying, among other things, the respect to private properties, are the paramount objectives of the said treaty as prescribed by democratic doctrine, that every human being needs to adhere, for the interest of global peace, which were carried over by many of our expeditions, that the Royal Crown had initiated. That the order of the Royal Crown in expedition for democratic endeavors and Christian values over the globe had been abused by you, as manifested by the vaudeville war of our royal armies through General Montojo and Admiral Dewey of the American government, degrading the grand flying color of the Royal Crown, destroying also the turpitude of the world-known Great America's historic record of the American government. Yet, we have no room in his highest office to admit you with such barbaric and inhumane acts you had done against our Christian brothers and sisters. The Filipino people certified true copy of the said letter, translated in English language, marked as an XI, and made integral part of government position paper during the hearing of the above titled case LRC/civil case number 3957P in 1969. Page 39, as appeared in the Madrid Protocol of 1885, signed by Spain, England, and Germany, under Article the 3rd of which the Spanish government renounced such claims over the archipelago as far as regards to the Royal Crown of Great Britain. That all claims of sovereignty over the territories of the continent of the Philippine Islands, including Borneo and the Tagean Islands now known as K.O.R.A.N Islands, which said Sabah belonged to the past Sultan of Sulu, with the conditions that island and income derived thereon should be apportioned into 2 equal amount in favor of the K.O.R.A.N heirs and the Tallano Tagean heirs. Now, very apparently, the invaders were not the Spanish Royal Crown and neither the Great Americans, but merely the Spanish Filipino mestizos who have had vested interest to grab the archipelago. If we will refresh our idea for the truth over the land in question, based on the government position paper and its evidences, ultimately, we could assess the veracity of ownership over said land of a person who has better rights and interest over the subject matter. It was admitted part of the position paper of the Republic of the Philippines under LRC/Civil Case number 3957P, that no less than the Chinese emperor named Yongle, as it was written in Sung and Ming dynasty between the year 1368 to 1644 AD, a symbol for the respect and due recognition of the Chinese Empire to the nobility of the King Luosang Tagean over his land ownership and rulership over the Page 40, archipelago that time already embracing 7,134 islands including that Sabah and Freedom Islands. The Chinese emperor gave him a gift of silk cloth and several tons of precious metals like gold, jewels as a token of tribute to the noble king whose name, Noble King Luosang Tagean, was adopted in naming the largest island in his honor, the island of Luzon by the said Chinese Emperor Yongle Chao-ti, that even to the earlier time, King Luosang Tagean regarded him by the foreign traders as king when there was no ruler over the archipelago, and that still, the ownership of the noble clan over the island of Mahalaca remained as historic landmark, while, later Manila, now Philippines, never gained any resistance nor opposition of any kind from various tribes of the inhabitants, which means directly admitting the vast of land over the archipelago was owned by the Tagean Tallano royal clan, who discovered, rebuilt, glorified and fortified from thousands of years by his predecessors. Indeed, the inhabitants of the islands Hacienda Filipina before, including Visayas and Mindanao, kept their respect over the said rights endowed to the noble family over the ownership of the archipelago including the islands of Visayas and Mindanao, by paying their share out of their harvest from the lands they were tilling for, and in behalf of the royal family, the Tallano Tagean clan. In 1405, the government of China sent an imperial decree in Manila affirming with vowed courtesy to the ruler of the archipelago consisting over 7,134 islands. By 1754, Dato Bantalan, brother of Alimuddin, sent a package of Sulu soil as tribute acknowledging that the Sultan desired the Sulu Islands be registered to China, but it was opposed by King. Page 41, Luosang Tagean. Instead, what was to be done was that the continent of China be registered to the islands of Mahalaca in respect to the King Luosang Tagean, considering by nature that China continent has been embraced by natural plate of the archipelago, which were proven by the historic payment of taxes of the Chinese from mainland, led by Emperor Yongle as tribute to the king. For long years of glorification and habitation to the archipelago, the noble clan had reverted the land of Mindanao to his cousins, the three sultans of Mindanao represented in the persons of Sultan Kiram Sinsert, Sultan Haji Kiram Missouri, and Sulu Sultan Muhammad Badarundin. Relatively, chosen the seat of the kingdom, and was finally settled in the Lamayan district in Santa Ana, Manila, long before Malacanang had been constructed by the conquistadors, where Lamayan name was also derived from the noble Lacan's wife, Lamayan Boan, having several descendants, and were honored as Rajas to their respective territories and sets Tagean royal guard, to protect 50,000 inhabitants living in the islands of Sabah, which is part of Philippine territory. These noble Rajas covered the entire Luzon, Visayas and some in the islands of Mindanao also, to help for the pacification of the social disturbances which exist up to the present created by the Muslim inhabitants, who were discontented of their plight in their lives, which are displaced due to the reason that their lands were confiscated by the friars. The second eldest son of King Luosang Tagean was named Raja Solomon, the one who controlled the entire area of Manila and its suburbs. Page 42, including the provinces of Rizal, Cavite, Batangas, Laguna, and the Carilea province now Quezon. Raja Lacandala, another grandson of the king, took over Tondo during the untimely demise of Raja Solomon. The third eldest grandson, Raja Gat Morban Tagean, who was married to the daughter of Bornean Sultan Abdul Qaha, the sixth Sultan of Brunei. Raja Sulaiman Tagean and his wife, Princess Tahata Acuna Acuna, have their begotten son, and was baptized into his name Prince Lacan Tagean, was adapted from his grandmother Margaret Acuna, Macleod Tagean. In the same manner, Prince Lacan Tagean Tallano has begotten son, as Prince Julian Macleod Tallano, and their descendants Raja Magat Salamat, who took over the area of Cagayan Valley. Raja Bajinda, the another grandson, had covered the area of Bohol, while another descendant, Raja Kabing Suran, took over the area of southern Mindanao. and Raja Lapilapu, the eldest son of King Luosang Tagean, took over the area of Mactan Island. Another grandson of the king was Raja Kalambo, the ruler of Limassol, and Raja Humaban, the eighth grandson, was the ruler of Cebu Island, and Raja Sikatuna, another of the king, assigned as the ruler of Bohol, while Raja Gat Morban Tagean, the youngest grandson of the king, took over eastern part of Quezon including Morban, Sampaloc and Lucban to protect the interest of his grandson Vicente Lucban. With the collaboration of the treacherous Filipinos, Legazpi succeeded to occupy Manila. That caused Raja Solomon, the king's son, fled to nowhere but to the forested area of Sierra Madre toward Malaysia, and married to the page 43, beautiful daughter of Alfred Dent, Mary Ann Dent, and during his absence, that made his relative, Raja Lacandela, took over Tondo, and welcomed Legazpi, and helped in rebuilding the city of Manila. Governor General Miguel de Legazpi, before his death by his effort, Royal Decree of 1572 has been issued under the Council of the Indies recognizing the Filipinos' patrimonial land and interest over their ancestral lands, including that of Tagean clan over Hacienda Quebaga and the entire archipelago, the Hacienda Filipina, which was in the name of King Luosang Tagean, while the purpose of dominion over the Philippine Islands was merely for the propagation of Christianism. Since the early Filipinos and even the noble clan coincided with the belief that there is only one God, our Father Almighty Bathala in Holy Trinity Santissima Trinidad, and under their K.O.R.A.N they called Allah. The noble King Luosang Tagean through his Raja's sons and descendants, remained determined to recover the so-called royal lands, the Maharlika Island including Hacienda Quebaga, which built out of their efforts, resources, and labors of several thousand of years of rearing it for man's habitation, to suit the needs of the inhabitants in the island. Yet, their war against the autocratic government of Spain was of no end. Much mire, they poured more resources, efforts, energies, and with their warriors, including the arms uprising of their farm tillers, to pursue rebellions for the realization of their aspiration, the ultimate recovery of their royal land and the independence of the island from any foreign dominion. The war outburst by the first Filipino. Page 44. Revolt in the year 1574 led by Raja Solomon's cousin, Raja Lacandela, then his nephew, Magod Salamat, the son of Raja Lacandela, who led the armed uprising in Cagayan Valley. Raja Lacandela helped Miguel de Legazpi in pacifying Central Luzon toward common goal of peace treaty, but the said peace treaty between the noble clans and the Spanish government deteriorated during the untimely death of Governor General Miguel de Legazpi, and had signaled the resumption of Filipino revolution against Spanish invaders by reasons of human abuses, injustices and unjust confiscation of private wealth and properties including ancestral lands of the inhabitants, the Muslims, and particularly the noble clans. The said Filipino revolts followed by Macleod revolt in Cagayan conspired by another king's descendants, Felipe Catibay and Gabriel Daag, followed by Tablet revolt in 1621 which followed to ignite into rebellion by the Bangkors rebellion in 1622 staged by another king's descendant in the person of Fernando Silang, the grandfather of Diego Silang of Ilocos. Then later followed by another Lacandela's descendants revolt known as the Ladia Revolt in the year 1643 that inspired the outburst of Sumuroy arms uprising in the 1649. This was followed by the king's descendant in the name of Francisco Maniago, who led the Maniago Revolt in Pampanga in the year 1860. The rebellion escalated to wider area of the archipelago up to Mindanao to recover the land of promise in favor of his Muslim relatives the sultans of southern Mindanao. Another revolt by king's descendants was staged in the person of Andres Malang who led the revolt in Pangasinan in page 45, the year 1660 to 1661 where he declared himself the king of Pangasinan with the confirmation of the noble clans, and followed by King Luosang's grandson's rebellion in the name of Francisco Dagahoy who initiated the rebellion in Bohol in the year 1744 to 1820, the longest revolt during that time, that had been followed by the agrarian revolt, comprising the farm tillers of the noble clan all over the island, which was known as agrarian revolt in the year 1745. To augment the efforts in rebellion successfully, Prince Julian Macleod Tagean Tallano, son of Prince Lacan Tagean Tallano, who was married to a beautiful daughter of a sixth Sultan of Brunei, Princess Amina Karam, her father Sultan Abdul Kahar, and whose family name was baptized from Tagean into a Spanish sound name, Tallano, redeemed the island from the US government in the amount of $20 million mortgaged by Spanish government, and sought succor from British Empire in the year 1761 that resulted into a military siege over the islands by the British Royal Army the dawn of October 5, 1762, that made the island rescued and freed totally from Spanish dominion in honor of the noble clan. The Tagean Tallano family had resulted for a period of 7 years British occupation in the archipelago. The date of the successful invasion of the British Royal Army, in helping the Filipino revolts and Tagean clan aspiration had augmented the mourn to death of the noble King Luis ang Tagean in December 17, 1764, who left of nothing but noble teachings, this bounty of bullion of gold, 720,000 metric tons, as legacies to his royal children and descendants, and to the inhabitants of Maharlika Island. Page 46. Now, Philippines, love to God, his creator above all, love also to his clan, to his fellowmen, and to his land he lives in with compassion and the preservation of justice for all, and with equal access for divine graces and opportunities toward common survival from adversities in life, where the golden teachings in his kingdom was paramountly important. The efforts of Manila liberation attributed to the noble clans by the Royal Military of Great Britain bear the fruit, to liberalize the island from Spanish government and the archipelago. The noble King Luis ang Tagean, almost 9 months after the issuance of the declaration of the said treaty, died in peace with happiness in heart could be reflected therein on December 17, 1764, exactly at 270 years of age upon learning the positive fruits of his efforts, which was the issuance of land title over the archipelago in his honor, issued by the British government embracing 7,134 islands embracing around 503,877 square nautical miles under OCT number T-01-44, and in the name of his grandson, Prince Lacan Tagean on December 17, 1764. And later to 16 years old Prince Julian Macleod Tallano in 1864. What the Spanish historian claimed, that the Philippines was discovered by Magellan in honor of the King of Spain, was entirely misleading and full of deception, because said claim was only an avenue to justify the declaration of cessation treaty between the American and Spanish governments involving the islands of the Philippines, Guam, Puerto Rico and Cuba in the amount of $20 million US dollars. This is in consequence of the orchestrated battle between the two led by leaders of the Page 47, to countries in the Philippines in the early dawn of August 13, 1898. While, the truth of the matter, the said dramatized war should not have happened, because of a protocol for peace between the two countries, Spanish and American, had been signed on August 12, 1898, signifying the truth that both Spanish and American governments were noble to agreed commitment for peace in the Orient, upholding the true spirit of democracy in the island of Manila, now Philippines, inasmuch as neither the US nor the Spanish government knew about the ill motive of Admiral Dewey and Spanish Royal Army General Montojo. Their guns, ammunition and their cannons started shelling the city of Manila, leaving several thousands of Filipino casualties after the traitor American Admiral and General Montojo of the Army of the Royal Crown of Spain, the expected defender of democracy, intentionally cut all the way out of the communication connecting the archipelago to the United States of America, that deliberately gave birth to the cessation treaty of the USA and of the Spanish Crown, which includes the conditions among other things as follows. 1. The ceding of the Philippines, Guam, Cuba, and Puerto Rico by Spaniards to the United States. 2. Payment of $20 million US dollars to the Spanish government by the United States of America, appearing not as purchase price, but only as generous gesture to American victory over its enemy, while Spain had secured loan to finance its war for invasion to the Philippines, but consequently causing another Filipino war against Americans. 4. Page 48, independence. That, indeed, Spanish government's general conspired with the US Admiral Dewey, defeating the truth that Spanish government has been losing to the Filipino revolutionists on the time that the archipelago had been acquired by the American from the Spanish government. The cessation treaty between the United States of America and the Spanish government ceded the Philippines, Guam, Cuba, and Puerto Rico in the amount of $20 million US dollars is abusive in character, because the Spanish government had no authority to cede the Philippines to the United States of America on the mere ground that the war between the two countries was merely a vaudeville one. Besides, beforehand, the entire archipelago then by the strength and help of Great Britain absolutely conquered and liberated by the British Royal Armies and Filipino warriors, after it worked the virtue of peace treaty between Great Britain and the Spanish Royal Crown, which was signed on March 31st, 1764, where the paramount conditions of the treaty was an absolute respect to the Filipino private property, including their ancestral lands, that directly controverted the alleged Spain's rights to the Philippines, which were acquired by conquest and physical occupation. Yet, claiming the Philippine archipelago became the property of the King of Spain was barred by peace treaty between Great Britain and Spanish Royal Crown. American ownership over the archipelago was no force and effect. Even the HHC law, better known as Harvey Harding Cutting Law, which was passed authorizing the restoration of page 49, American ownership over the lands, including that of private property in the Philippines for American government military reservation and other purposes, because said law had been vetoed by U.S. President Harding, requiring its further review, and this was caused by a repassing by U.S. Congress with overwhelming votes for an inclusion of a provision that said HHC bill be accepted by Filipino legislators by the Filipino people in a plebiscite. In lieu of the congressional initiatives over the Philippine Islands, the said HHC law had been rejected by the Filipino legislators because it totally deprived the basic rights of the royal family, the Tagean Tallano clans, and the Filipino people over the lands in the Philippines. Indeed, long beforehand, ownership of the noble clan, the Tagean Tallano clan, over the archipelago had been concretely rectified upon the creation of the Supreme Court in 1580. It decided the said case under the royal audiencia, initiated by Governor General Miguel de Legazpi in 1572, where said royal decree of 1572 had been issued requesting ownership of the royal family to the entire archipelago with exemption that the island of Mindanao be reverted back to the noble king's cousins, the three sultans of Mindanao, led by Sultan Sinsat, Sultan Haji Kiram Missouri, and Sultan Siranga, now in the name of Princess Aminata Kiram, the granddaughter of King Louis ang Tagean, particularly the land of promise, the island of Mindanao, that should be inherited by their relative Muslim families. The creation of the royal audiencia establishing a Supreme Court in the Philippines had been successfully done on May 5, 1583. Page 50, followed by the issuance of Supreme Court decision deciding that portion of the island of Mindanao were absolutely owned by the three aforementioned sultans, allowing their Muslim brothers to own portion of land they live in with preference over their Christian brothers. The Spanish cohorts who have eager interest to grab the lands of the noble family remained in their influence. That caused the passage of the HHC law, but was turned down by both U.S. Congress and Philippine legislators. Such evil intent had never ended, and the same were inherited by those of similar intention like the Spanish Mestizo/Filipino families in the Philippines. These Spanish Mestizo Filipinos even sought seats in the Philippine Congress and key positions in the Philippine Commission like the Tuazon, the Ortigas, and the Iranitas. They eventually established similar political interest in the Philippine Commonwealth that caused the passage of repressive laws. Its focal objectives were to dispense the interest of the noble family over the royal properties, besides of their intention to manipulate the records of the said lands, to follow suit their own interest, and to maneuver for the reissuance of another titles that would subside the titles of OCT T-01-4 of the royal clan over the subject parcel of lands. These repressive laws were as follows: Array 2259, better known as the Cadastral Act of March 14, 1914, and the Republic Act 496, better known as the Land Registration Act of 1902, but these laws, later on, were found to be ineffective considering that the land had been covered by eligible good title probative origin, under OCT number 01-4. Page 51. Which was found registered anew in the name of Prince Julian Macleod Tallano I, the father of Don Esteban Benitez Tallano, the descendants of King Louis ang Tagean. The said OCT, which was issued in 1764 in the name of Prince Lacan Acuna Tagean by the British royal government, and which were appealed in the royal audiencia in 1572 by Don Hermogenes Rodriguez and his brother, claiming the said island was a reward to their grandfather, a general of Spanish army. Rodriguez de Figueroa gained fruitless efforts, but later on, under the Spanish encomienda system by the order of the royal audiencia, the decision had been maintained on the year 1864 to and in favor of Prince Julian Macleod Tallano, the grandfather of John Tallano Macleod. Now, the issue as to the legality of ownership of the American government over the subject land was whether or not said land is lawful to be inherited by the Philippine government from the US government. Certainly, based on the evidences and circumstances, the ownership of the Philippine Republic and its government over the subject noble lands was void and unconstitutional, even if the basis was a Philippine Constitution of 1935, but neither the Malolos Constitution could warrant the legality of Philippine government ownership over the said lands on the reason that US government acquired unlawful rights over the land. The same, it thwarted the evil interest of the Republic of the Philippines over the subject royal properties, the entire archipelago and hacienda Quebaga. OCT number T-01-4 represents the whole archipelago, and represents four regions: Luzon, Visayas, Palawan and Zamboanga, embracing Tagean, K.O.R.A.N and Sabah, and that Mindanao region. Page 52. The Philippine government under LRC/civil case number 3957, P controverting the evidences of the plaintiff and the defendants, namely the Macario Rodriguez and heirs, Wilson P. Orfanada and heirs, Hermogenes Rodriguez and heirs, Fortunato Santiago and heirs, Pedro Rojas and heirs, the administrator of San Pedro de Macati, the Triple and Pasay City Estate, the Don Mariano San Pedro Esteban and heirs, Jose M. Tuazon and Lourdes Tuazon and heirs, the Manada de Ocampo Buhain, Jose de Ocampo and heirs, the administrator of Miracaban Estate, Patricia Shiangson, Ponciano Padilla, et al. During the hearing and part of the government's position paper and documentary evidences, including those of circumstantial and testimonial evidences which were submitted in the cellar of Honorable CFI Judge Enrique Agana, Branch 28, CFI, Pasay City, it reaffirmed the legitimate claim of the Tallano supported by the following evidences, to wit: 1 OCT number 01-4 in certified true copy procured by the Office of the Solicitor General, and marked as Exhibit E1 back of title, which said title is in the name of Prince Lacan Tagean Tallano, and the same was on file in the Honorable Register of Deeds Office in Morong, now Rizal, and had been transferred to the province of Manila, and lately to the Bulacan Register of Deeds, due to the fact that Malolos became the last seat of Philippine government. Page 53, 2. TCT number T408, in certified true copy, procured also by the Office of the Honorable Solicitor General in the name of Don Gregorio Madrigal Acop, issued by the Register of Deeds of Pasig, marked as Exhibit A. Exhibit A1 back of the title, and made as integral part of the Republic of the Philippines position paper. 3. TCT number T498 in the name of the Don Esteban Benitez Tallano, a certified true copy, issued to the Office of the Solicitor General by the Honorable Register of Deeds of Malolos, Bulacan, marked as Exhibit E. Exhibit E1 back of the title, and made as integral part of the position paper of the government, the Republic of the Philippines. 4. Tax declaration of the real property in the name of Don Gregorio Madrigal Acop, issued in a certified true copy by the Office of the Provincial Assessor in Pasig. 4. In the name of the Honorable Solicitor General, and marked as an XB, and made as integral part of the government's position paper. 5. Tax declaration of the real properties covered by TCT number T498, in certified true copy in the name of the Don Esteban Benitez Tallano, issued by the Provincial Assessor of the Province of Morong, now Rizal, but it was transferred to the Provincial Assessor of the Province of Bulacan as requested by the Office of the Honorable Solicitor General, and marked as Exhibit C, and the same was made integral part of the government's position paper. Page 54. 6. Certified approved plan the 2nd 69, decree number T-01-4 protocol embracing the whole archipelago of the subject real properties for in the name of Prince Julian Macleod Tallano covering the properties under OCT number T-01-4 and marked as Exhibit B, and made as integral part of the government's position paper. 7. Certified approved plan Suit 2031. Decree number 297 of the real properties under TCT number T-408-4, and in the name of Don Gregorio Madrigal Acop containing an area of 125,326.37 hectares marked as Exhibit E, and made as integral part hereof for the position paper of the Republic of the Philippines. 8. Certified approved plan Suit 2031. Decree number 297 of the real properties under TCT number T-498-4, and in the name of Don Esteban Benitez Tallano covering an area of 271,276 hectares, marked as Exhibit F as requested by the Honorable Solicitor General and made as integral part of the position paper of the Republic of the Philippines. 9. Cash vouchers marked as Exhibit A2 to A19 as evidence of yearly rental of the Republic of the Philippines to the landowners, Don Esteban Benitez Tallano and Don Gregorio Madrigal Acop. Said documents were issued by the Office of the President in the year 1966 upon the request of the Office of the Solicitor General, and made as integral part of the government's position paper. Page 55. 10. Sworn Affidavit Paragraph C of Honorable LRC Deputy Administrator Gregorio Belog Jr., which was incorporated in a government's position paper declaring that OCT number 01-4 which was registered in the name of Prince Lacan Tagean Tallano forged in favor of Hermogenes Rodriguez, marked as Exhibit H, and made as an integral part of the government's position paper. 11. Paragraph D of government's position paper declaring the following TCTs as fraudulent no probative value, such as OCT 4136, OCT 369, OCT 408, OCT 498, OCT 779, OCT 333, OCT 291, OCT 160, OCT 242, OCT 632, OCT 339, OCT 2410, OCT 393, OCT 543, OCT 632, OCT 549, OCT 847, OCT 730, OCT 735, OCT 614, OCT 529, OCT 291, OCT 994, and the TCT number 2288. TCT number 30226, TCT number 8037, TCT number 56339, TCT number 281827, TCT number 281828, TCT number 302226, TCT number 409, TCT number 478, and that OCT number 1 up to OCT number 4085 and OCT number T4086 to TCT number T100,000 which were declared null and void by LRC Administrator Antonio Noblijas, and was reciprocated by circumstances and severally upheld by the Supreme Court in later years, and made as integral part of the position paper of the Republic of the Philippines. 12. That certification of NBI Director Jolly Bugarin, with his sworn affidavit marked as Exhibit D34, and made as integral part of the government's position paper manifested that all land titles marked under Exhibit D1 to D33 were fraudulent and derived from spurious origin. Page 56. 13. Sworn affidavit which was incorporated in government's position paper, paragraph E of Honorable LRC Administrator Antonio Noblijas declaring that both TCT number T408 and that TCT number T498 were eligible, and with probative values in favor of the landowners, Don Esteban Benitez Tallano and Don Gregorio Madrigal Acop, marked as Exhibit J, and made as integral part of the government's position paper. 14. Paragraph F of the government's position paper manifesting that Royal Decree of June 25, 1880, Article 4 and Article 5, declaring the subject properties under TCT number T-408 and that TCT number T-498-4, and in the name of Don Esteban Benitez Tallano and Don Gregorio Madrigal Acop including that Hacienda Filipina under OCT number 01-4 marked as Exhibit G, and made as integral part of the government's position paper, are exempted from the requirements set forth in the said decree. Considering that such land are private property by origin owned by the clan. 15. Paragraph H of the government's position paper, marked as Exhibit L, and made as integral part of the government's position paper manifesting and declaring that Royal Decree of 1571 and July 15, 1881 and October 26, 1881 and that the Mora Law, known as Royal Decree of February 17, 1894 had recognized the eligible ownership of the landowner, Prince Lacan Tagean Tallano, and eventually to Prince Julian Macleod Tallano I, over the land. Page 57. Covered by OCT number 01-4, thereby the said land had been exempted from expediencies and or adjustments of its area, considering that the subject land had been titled so long under virtue of Royal Decree 01-4 protocol as adopted by the Royal Audiencia in the Philippines, and had recognized as well by the Philippine Commission then, considering further that the subject land, the same had gone under the trial of R.A. 2259 that tested the credibility of land area and its eligible ownership over the land. 16. Paragraph I of the government's position paper declared that Don Esteban Benitez Tallano and Don Gregorio Madrigal Acop died during the Japanese occupation, and left no will, and legitimate heirs whosoever, but it was controverted totally, and denied by rebuttal evidence of the interveners. Because in due time, the subject heirs were summoned and appeared physically in open court. 17. Paragraph G of the government's position paper declared that both Hermogenes A. Rodriguez and Miguel Antonio A. Rodriguez left the country on the year 1932 in sine labias in contrary. The same was not being rebutted by the heirs of the Rodriguez. 18. Paragraph K of the government's position paper manifested with Supreme Court Chief Justice O.C.P. Laurel dissenting opinion. It declared all presidential proclamations, executive orders, letters of instructions and decree of any purpose or purposes had no force and effect over real properties covered by K.O.R.A.N's Title 4 and in the Page 58, name of private persons in the absence of just compensation. 19. Certified copy of the excerpts from the sworn testimonies of NBI Director Jolly Bugarin before the Senate Blue Ribbon Committee headed by the ex-Senate President Jill Puat, and made as integral portion of the government position paper divulging several modus operandi of those in the LRC Bureau of Lands before. In conspiracy of those influential group in the government in the massive issuance of fake land titles affecting the titles of the Tallano, OCT number 01-4. TCT number T-498, and that TCT number T-408 in the name of Don Gregorio Madrigal Acop, in favor of the land grabbers and oligarch real estate developers as they were benefited by those who could pay a lucrative sum. The modus operandi are as follows: the grand design, land grabbing of the LRC Bureau of Lands in conspiracy with their cohorts real estate developers has caused the root of some 20 million fake land titles over the subject lands under the following procedures. Scheme 1. 1. Issuance of new approved survey plan in pre-patent. 2. Issuance of pre-patent original certificate of title at a price of P5.00 per square meter, and for better price, the LRC Register of Deeds people mutilate pre-patent OCT for the Page 59. Immediate issuance of transfer certificate of title in the name of the conspirator fraudulent landowners. Scheme 2. 1. Issuance of antedated approved survey plan with microfilm. 2. Issuance of antedated decree over the subject land with some Spanish character and language. 3. Issuance of antedated OCT to TCT in exchange of P20.00 to P30.00 per square meter, depending on the location of the land with Spanish character and language. Scheme 3. 1. Issuance of antedated approved survey plan with microfilm. 2. Issuance of antedated decree. 3. Issuance of antedated title from OCT to TCT in exchange for P30.00 to P40.00 per square meter, For those who cannot pay in spot cash, the applicant will be required to pay 50% down payment and the land title would be released in exchange of letter of guarantee of payment by the financing private bank, or, most of the time, by the government financing institution through the recommendation of those influential persons from Malacanang Palace, then. Page 60, Scheme 4, 1. Issuance of antedated approved survey plan in the name of LRC Bureau of Lands employees, cohorts, and relatives. 2. Issuance of antedated OCT, and then TCT in the name of their cohorts and relatives. 3. Then sells the land to the developers or buyers. 4. Beforehand, the developers claimants would be engaged in the hiring of professional squatters to occupy the area before the document of ownership is processed to guarantee the occupancy of the land. Scheme 5 for those influential persons in the government. 1. Issuance of government infrastructure permit to the applicant to occupy the land. 2. Fencing and installing paid security personnel. 3. Through recommendation of Malacanang Authority, applicants procure development loan from government financing institutions, and eventually for approval by mere presentation of the following: A. TCT from fake origin to procure. 1. Building permit with project plan. 2. Authority to develop and permit to sell issued by the Department of Public Works, Building Permit Division and the Human Settlement Regulatory Commission HSRC. Page 61. 3. Most of the developers absconded the funds that had released under bank loans to diversify into another project but some pursue the development as regular business like those thriving real estate developers who became millionaires under the blessings of these schemes, to the predicament of the legitimate landowners, the noble clan, and finally to the damage of the general public. Apparently and inevitably, an affirmation of Tallano's ownership over the land, Hacienda Filipina, has been given further consideration, reaching the question on what legal interest anchored to the subject lands that the Republic of the Philippines could show better right than the ownership of the legitimate claimants, Don Esteban Benitez Tallano and Don Gregorio Madrigal Acop, and heirs of the Tallano and Acop. On this legal point of view, while based on the evidence OCT number T-01-4 was in the name of Prince Lacan Acuna Tagean Tallano, the government never possessed said better ownership and legal rights over the land than what the heirs, having as much as the legal heirs remained physically fit, alive and kicking, and controverting strongly the deceptive allegation of the Republic of the Philippines that the said owners and heirs over the subject land were dead, and no survivor to claim it, so it should necessarily be reverted to public domain, are allegations full of deceptions and purely hearsay. Page 62. Besides, the legal ownership rights of the Tagean Tallano heirs are fully supported by strong evidences of ownership over the land adapting the evidences of the Republic of the Philippines, but the claim for ownership by the government in that paragraph I of the government position paper over the same subject land has been strongly opposed under the principles of prius tempore portia juri by the Tallano Acop. Considering that no less than the amicus curiae in this court were the ones that confirmed the legitimacy and the physical evidence of the said landowners, besides the alleged expropriation by the government over the subject land in favor of the legal owners/heirs had not been consummated, that forced the Philippine government to file a motion for issuance of a separate decision with compromise agreement with the lawful owners to protect the land actually occupied by its government buildings and its agencies' offices, including local government offices and instrumentalities. Besides, the allegation of the Honorable Solicitor General to settle ownership first once and for all over the land, covered by OCT number T-01-4 and including necessary reconstitution of lost owner and duplicate copies of the original, OCT number T-01-4 relative to the cases they are accusing this honorable court for non sequitur, is purely blatant lie and deception beyond the basis of truth, because Movent himself, through its Honorable Solicitor General, failed and continuously failing to prove its better and stronger rights over the land in question against the rightful owner's evidences, its merit is undoubtful on the reason. Page 63, that the same had been used as government's evidences against the plaintiffs and the defendants in the case at bar. So, now, how can we subscribe such evidences that had been used by the government for its interest and offenses reflected in its position papers, that the same evidences had been presented by the Tallano's heirs as its primary evidences are fraudulent in character? Can it be that the government a direct source of fraudulent evidences? Certainly not, according to LRC Commissioner Antonio M. Noblehas. Therefore, the government should be barred by statute of limitation and or estoppel for public interest, since people demand honest services from the government. As here under word derived from the text of the government position paper, pages 2 and 3, read as follows, that neither the plaintiffs or Fernanda or defendant Macario J. Rodriguez or any party in interest herein mentioned, has valid rights over the land in question inasmuch as the subject lands containing an area of around 125,326.37 hectares, evidenced by TCT number T-408 duly registered in the name of Don Gregorio Madrigal Acop in the Register of Deeds of Pasig for the province of Resol. And the land is not covered by OCT number 4136 as earlier claimed by the heirs of Don Mariano San Pedro Esteban, nor it is covered by OCT 369, OCT 735, OCT 333, OCT 33, OCT 543, OCT 844, OCT 730, OCT 734, OCT 994, OCT 614, OCT 820, OCT 779, and no other titles, except that OCT T-01-4 and that TCT number T-408 and TCT number T-498 as claimed by the Republic of the Philippines, while the truth of all, said TCT number T-408 had been derived from OCT number 01-4, the only original certificate of title that embraced the whole archipelago including the areas of page 64, Visayas and Mindanao, the paramount title of them all. And that all land titles in OCT, that has a number from 01 to 100,000 which was amended from OCT 01 to OCT number 10,000, should be cancelled for being fraudulent titles, yet, means not existing at all, except that OCT 01-4 which was registered in the province of Morden then, the copy of the eligible and original one, but was altered in Batangas Register of Deeds as OCT 0-14 and Luhia offers the fundamental foundation of truth. Even then, the same, said OCT number 01-4 with presence of those land titles, it cannot deform, nor destroy its probative value for the rightful owners under the principle of K.O.R.A.N system. Annex A, a certified true copy of TCT number T-408 that was issued by the Register of Deeds of Pasig for the province of Resol, and not of the Register of Deeds of Quezon City as earlier alleged by the defendants, Ortigas and Company, to as an company partnership, Eminada de Ocampo Buhain, Pedro Rojas heirs, Hermogenes Rodriguez heirs, Patricia Shiongson heirs, Eulalia Agassiz heirs, Don Mariano San Pedro Esteban heirs, while other defendants failed to file their answers within the reglementary period. However, Dominada de Ocampo Buhain, the claimant of the same area under an alleged OCT number 779 which was marked as an XA, and at the back of it was marked as an XB, and had made as integral part hereof were found with similar nature, and no force and effect. The annotation of the deed of absolute sale, however, that covers the portion of the subject lands under TCT number T-408 in the name of Benigno Toda of the Philippine Airlines for his 75 hectares he acquired from Don Anacleto Madrigal Acop are here to attached as well. While the page 65, intervener Julian N. Tallano, who acquired an area of 15,195.933 hectares together with the area he acquired in the province of Cavite containing around 94,666.37 hectares from his grandfather, Gregorio Madrigal Acop, are here to attached and made as an integral portion hereof. Paragraph D of the government position paper which reads as follows. That another TCT number T-498, and not TCT number 409 as the Rodriguez claims, embracing the land area of around 271,276 hectares, covering the same towns of the province of Morong, now Resol, Bulacan, Quezon-Quirilla before includes Dingalan, Real, Infanta, Naca, including that of the Greater Manila area, the whole of Cavite, Quezon City, Caloocan City, portion of Bumban, now Batangas, like Laurel, Tal, Lemery, Talasay, Nasugbu, Lipa, Navitus, Malaban, Mikoayan, Valenzuela, Santa Maria, Norzagaray, Jose del Monte, Angat, and Bokor, for the Bulacan, Tete, Morong, Palilia, Jala Jala, Beris, Teresa, Tane, Cardona, Angono, and Tapalo, Cainta, Marikina, with the same land title was derived from OCT number 01-4, a land title of probative value which was issued by virtue of Royal Decree of 1764, and was rectified by the Spanish mortgage law in the name of Prince Lacan Acuna Tagean Tallano. Indeed, it had no other land title, except of the above, and, if there be like these alleged OCT 4136, OCT 735, OCT 820, OCT 904, OCT 33, OCT 844, OCT 333, OCT 160, OCT 291, OCT 209, OCT 498, OCT 4085, OCT 543, OCT 2573, OCT 614, OCT 393, OCT 374, OCT 730, OCT 632, and that all OCT from 01 to OCT 4085, then from OCT 4086 to OCT 100,000, which were confirmed by the land registration. Page 66. Commission LRC and the NBIS fraudulent land titles. Upon motion of the LRC through the Solicitor General, the same land titles were declared null and void ab initio, and enough ground to cancel these titles. It was on the part of this honorable court to order the Register of Deeds of the places where the lands are situated to cancel and nullify the aforementioned land titles which remained enforceable against the legitimate land title OCT number T-01-4, eroding the stable and sound foundation of K.O.R.A.N system. And if ever these fake land titles are on file with the said Registry of Deeds of the place where the land is located, necessarily the concerned Register of Deeds should cancel the same for conveyance in favor of the rightful owners, the Tallano, et al. The certified true copy of the said TCT number 498 was duly presented by the Office of the Register of Deeds of the Province of Bulacan by virtue of the motion of the Solicitor General, attending for the issuance of subpoena duces tecum to the Honorable Register of Deeds, is hereby marked as Annex E and D1 at the back of the title. While that Annex D to D19, photocopies of the titles of the land in question and lawfully issued by the perpetrators in the LRC, and of the Registry of Deeds of the concerned towns and municipalities, and by the province that covers the areas, evidenced by the certification from the LRC Records section, pertaining to the above cited land titles, including the fraudulent copy of OCT number 01-4, which is far identical from the copies of the eligible one that was falsified and had presented by the alleged heirs of Hermogenes Rodriguez, had been marked as an XH, and the same had been declared by this honorable court as null and void, and are cancelled land titles ab. Page 67, initio. The same which were marked as Annex C and Annex D to D19 are hereto attached and made as integral part hereof. Paragraph E of the said position paper of the government, excerpt therefrom and read as follows, that both TCT number T408 and TCT number T498 are titles from origin of probative value, and were derived from OCT number 01-4, embracing the whole archipelago, islands of Luzon, Visayas, Mindanao, and Palawan Peninsula, embracing the Sabah Island and the Tagean K.O.R.A.N Islands, for a total of 7,134 islands, which manifested that OCT number 01-4 as it presented the whole archipelago for that 01, and mentioned 4 major islands representing 4, or in clear idea, 01-4. And not only embracing 7,100 islands, which was mistakenly defined by the 1935 Philippine Constitution. Said OCT that was issued on the year 1764 had been rectified by virtue of Royal Decree 1864, which is bankable in accordance with Spanish mortgage law, together with its expedient land titles, TCT number T408 and TCT number T498. which are Torrens titles in character, a certified true copy, authentic and genuine copy of said OCT number 01-4 with the certification from the record section of the LRC duly issued through the effort and request of the Office of the Solicitor General are hereto attached, and marked as Annex F and F1, and are made as integral part hereof, page 68. Paragraph F of the government position paper excerpt therefrom, which reads as follows, that the government has the sole absolute right over the land in question under principle of eminent domain, and by virtue of expropriation proceedings the government has undertaken between and in favor of the landowner, Don Esteban Benitez Tallano. As a matter of evidence, Annex A to Annex A19 are cash vouchers amounting to P20 million pesos, showed the landowner receiving a yearly rental of P1 million from the national government for a period of 20 years, since the signing of the administration of the late President Manuel Rojas in 1948 and ended in 1968 respectively for the use of the Ballara water reservoir facilities, including other lots occupied by other government agencies, including also the roads and highways that have been utilized for public welfare, clearly manifested that the Republic of the Philippines has a preemptive rights to buy said lands from the landowner, Don Esteban Benitez Tallano. Considering that said landowner has been receiving a rental payment from the government, yet, it should be treated as an initial payment of that ongoing expropriation proceedings. Annex A to Annex A1 to A19 are hereto attached and made as integral part hereof. Paragraph G of said government position paper, its context excerpt therefrom, reads as follows: report of the Senate Blue Ribbon Committee, led and initiated by Honorable Senate President Julian Sr., who conducted the investigation over the reported land scam to restore the trust and confidence of the Filipino people over. Page 69, the strength and wisdom of K.O.R.A.N system in the country subsiding, said paramount interest, while national security is at stake participated, and had connived with one another by the employees of the Department Works and Highways, Building Permit Division, those in the LRC, and in the Survey and Record section of the Bureau of Lands, including employees of the Register of Deeds of the affected towns and municipalities, and the covered provinces, in massive issuance of falsified land titles ranged from OCT 01 to OCT number 100,000, embracing the subject area to the embarrassment of the national government, which were taken advantage by irresponsible real estate developers, local and barrio officials who were directly engaged in the selling of rights of the subject land. By way of controlling and fencing it, control it and post it with billboards and sell it to the developers. The said report marked as Exhibit G, and was duly issued by the Record section of the Philippine Senate in the year 1968, and had made as an integral part hereof. Paragraph H of the government position paper, its excerpts are read as follows: sworn statement of LRC Deputy Commissioner Gregorio Bilog Jr., attesting to the facts, that there are actually massive issuance of spurious land titles embracing the land in question, which involves not only 10,000 fake OCT, but an estimated 100,000 fake land titles and original certificate of titles were originated from OCT 01 to OCT 100,000, etc. not as previously divulged by the LRC, ranging from OCT 01 to OCT 10,000, but clearly in favor of the government cohorts in exchange of lucrative sum which said anomalous titling. Page 70, originated during the time of Antonio Noblijas, and in connivance of his staff, in the LRC then, which were remained employed in the LRC, and earlier during the time of Zoilo Castillo, the designated administrator of the defunct Rural Development Administration RDA, later as Administrator of Land Tenure Administration Office, who was tempted by million amount of pesos in some way, that caused the massive issuance of land titles of the subject lands, some in favor of PHHC, then now on its new proposed name NHA, after the pertinent papers and records relative to OCT number 01-4, TCT number T408, TCT number T498, together with that PSU 2031, were depleted its area of coverage, and altered in favor of Miracaban Estate, while the second 69, the same, its records were uprooted, and were changed to another ones. Beside the technical description of that decree number 297, the same were altered and depleted into area of smaller coverage, which has been confined in Cavite province alone, defacing its credible and probative value, and legal purposes were destroyed, instead its greater coverage to Greater Manila area. and some data of the land were altered for the interest of the conspirators buyers of the subject lands. This sworn statement of the witness had been marked as an XH, and had made as integral part hereof. Paragraph I of the government position paper, where the testimony is of former DOJ Secretary Salvador Merino, then before the Senate Blue Ribbon Committee, and was used on the year 1968, and it stated that the government could not be a source of fraudulent land titles, denying vehemently the accusation of the Tallanos on the simple reason that the page 71 confidence instituted to protect the welfare and interest of the people and its citizenry. The government had issued only one land title, OCT number 01-4, for the whole archipelago, and that its expedience is TCT number T-408 for the whole cavity, Greater Manila area, portion of Batangas, whole of Resol and a portion of Laguna, and that TCT number T-498 for some municipalities and cities of the Greater Manila area, portion of Resol province, portion of Quezon province and Bulacan, and thereafter, if any other land titles exist other than those land titles alleged to be fraudulent land titles in character, and are null and void ab initio, particularly in Batangas Registry of Deeds, they issued OCT number 0-14 to destroy the credibility of the K.O.R.A.N's title OCT number 01-4. On the issued, raised by the Honorable Solicitor General pertaining to a defective ownership of the Tallano over the subject land, which was alleged as unenforceable on the mere reason that the vendor had not completed the requirement of the sale involving the subject land, which is the physical delivery of the land assigned to the Tallano heirs, said argument is only applicable for the sale of movable property. In a universal acceptance involving real estate transactions, in consonance to a propriety rights and adapted doctrine enforced by the wisdom, if the Land Registration Act, physical delivery of the land sold by the vendor to the vendee, is only a matter of satisfying the principle of fee simple, which can be done by way of execution of public instrument on conveyance and the corresponding registration of the deeds, which is an operative act that transfers and binds the lands. The said page 72, procedure is well taken in a case, Bautista vs. Ixcond, 70 Phil, 398, and the same was enlightened many times by the Supreme Court decision in similar circumstance, and finally actual possession over the land, acquired and purchased, is merely incidental to the ownership title. However, the same procedure had been applied by the Tallano's heirs, when they registered the land area they acquired from the landowner. Both Don Anacleto Madrigal Acop and Don Esteban Benitez Tallano registered their ownership by annotations at the back of the title number T-408 and duly recorded in the Register of Deeds of Pasig and the province of Resol, before the relevant documents were reported vanished. The issue that the titles TCT number T-408 and TCT number T-498 has no longer probative value on the reasons that the Spanish titles and Spanish mortgage law is supposed to be abrogated for national interest, on salient point that said land titles cannot facilitate the purpose of the true owners. Said argument is baseless on very reasons that, as manifested by the Tallano's heirs, said TCT number T-408 and TCT number T-498 could not be affected by the laws, which are not yet enacted, even if for national interest, although it come from its origin of CCT number 01-4, Spanish title Paresi, but said OCT number 01-4 was registered on October 3, 1904, so its corresponding decree of registration, particularly Decree number 297 and Royal Decree 01-4 protocol as it had been issued on that same date, confirming that the said land had been covered by a Land Registration Act 496. It clearly connotes beside of that another land authority requirements under Cadastral Act 2259, the subject land had been placed. Page 73, for compliance so PSU 2031 and Plan the Second 69 for the whole archipelago had been issued affirming that there were cadastral survey over the estate, and were approved on March 6, 1915, March 4, 1916 and September 9, 1916, respectively, clarifying absolute ownership of the landowner, late Prince Lacan Acuna Tagean Tallano. That said TCTs, specifically TCT number T-408 and TCT number T-498 furtherly, are already land titles in K.O.R.A.N's character. Besides, any law proclamation, ordinances, letter of instructions or decrees have to retroactive effect over the land, evidenced by T-O.R.A.N system. And the same OCT number T-01-4 and TCT number T-408 and TCT number T-498 cannot be nullified inasmuch as the judgment of the Land Registration Court had met the prerequisites of jurisprudence over the land case for registration, and had been rendered by the judge who handled the land registration proceedings. In accordance with due process as the requirements set forth by the law, Rule 132, and of Rule 135 defined by the Rule of Court of the Republic of the Philippines. Going back to the main aspect of the motion of the Republic of the Philippines, to resolve first ownership over the said land, covered by OCT number 01-4 is tantamount of a petition for the rehearing of the case, a manifestation of rising the dead from the tomb, in a clear sense which is obviously unconstitutional. Ultimately, it is for a revival of the case which this presiding judge had lost his jurisdiction over the case after the decision of the Land Registration Court had been finally decided, and correspondingly terminated upon issuance of Decree number 297. Page 74. PSU 2031 for the Greater Manila Area in that Royal Decree 01-4 protocol with that the second 69 executed, and had been reaffirmed and registered in the Land Registration Book, and it had sustained by operation of the law, which held on October 4, 1904. For the issuance of Decree number 297 in favor of the Tallano, which, indeed, all rights and interests thereat embracing the land in question, were completely turned over to the Tallano's heirs. And their titles and interests prescribed in that judgment has remained sustainable and enforceable in Coram nobis. But let us analyze the context of the provision of Section 1, Rule 52 and at Section 1 and Section 3, Rule 121 of the Rules of Court, which read as follows: Rule 52, Section 1, Motion for rehearing. A motion for rehearing or reconsideration shall be made ex parte, and filed within 15 days from notice of final order or judgment. No more than one motion or rehearing or reconsideration shall be filed without express leave of court. A second motion for reconsideration may be presented within 15 days from notice of the judgment or order deducting the time from which the first motion has been pending. Certainly, this is true in the case of government against the rightful owner. Said reopening of the case is impossible to be happened. Otherwise, the Republic is guilty of res judicata. In the motion of the Republic of the Philippines dated March 8, 1971 to resolve the ownership over OCT number 01-4 in their favor in the absence of the legitimate heirs of Prince Lacan Tagean Tallano, which was denied on June 7, 1971, and another motion, but the same was denied on August 19, 1971. Page 75. Again, it was on their same allegation that notice of hearing had been received by their office only on May 7, 1971, were clear manifestation for dilatory tactics of the government. Like previously, as alleged, they only received said corresponding notices on April 19, 1971, yet, their constitutional rights, as alleged, were buried for quite some time without the privilege of due process. Said reasons were made as repeated alibis, illogical and irresponsible form of reasons, but merely as an scapegoat to their gross negligence, because it turned out that they were inconsistent to the existing court records pertaining to proofs of mail and sheriff's services, which were very evident after the written certification of the Chief Registry Division Manila Postal Office that had been issued. Said notices were delivered as evidenced by registered mail with return cards through the Manila Postal Service. Indeed, they succeeded for the issuance of July 14, 1964 decision nullifying above given OCT from OCT number 01 up to OCT number 100,000 in favor of the Republic only. I repeat, the decision had been reversed by way of intervention filed by the heir of Don Esteban Benitez Tallano, in the person of Benito Agustin Tallano, opposing not the cancellation over the fake titles, paresi, but the award of reconveyance to the Republic of the Philippines by reason of no eligible heirs of the true landowner. We cannot furtherly sustain the argument of the Honorable Solicitor General as to retroactive effect of that incoming laws, even if for national reasons, because it would create great menace all over the country, since the law has no Page 76. Retroactive effect over the probative value of TCT number T408 and TCT number T498 and that OCT number 01-4, because the said titles are Torrens titles in nature, although it came from the origin of OCT number 01-4. A Spanish title, Parece but duly registered under Land Registration Act 496 on October 3, 1904. And under Cadastral Act 2259, an essential requisite of Torrens title. Generally, as it turned to usual practice once a land title in OCT successfully transferred into transfer of certificate of title, it absorbs the characteristics of being Torrens title, which has been adopted for many years by those in the real estate business, and by the land authority, except when we will reverse the method. Yet, if ever we do so, it is a direct aversion to the rules and policies prescribed by Land Registration Act 496, which reciprocally deteriorate the virtue of Torrens system. Besides, such motion of the Republic of the Philippines as, I repeatedly quoted, cannot be given due consideration on the sense that the case had been closed and terminated finally, to resolve the ownership issue, since the year 1904, after it became final and executory, and the same was executed as started here, in which this contention had been subscribed by no less than Honorable Solicitor General Felix V. Macleod in his defense in a case, People vs. Pinula, et al., Supra, which read as follows: even so, it may not be disturbed and modified. Our recent interpretation of the law may be applied to new cases, but certainly not to an old one finally and conclusively determined. Page 77, and it has been held in a case, 21 CJS 330, cited in People vs. Pinula, et al., Supra, that law is a present and prospective force, that law needs some stability of administration, that the law is all the law there is, that law is more for the parties than for the courts, that people will rely upon, and adjust their behavior in accordance with the laws, be it judicial or legislative or both. Corollary to the motion for the issuance of reconstituted copies of both owner and duplicate copies of the original of OCT number T-01-4, let us diagnose the legal impediments that had arose in the accounts of the opposition of the LRA through its Honorable Administrator Antonio Noblijas against the issuance of the owners and duplicate copies of the said reconstituted land titles, particularly the OCT number T-01-44, and in favor of the heirs of the late Prince Lacan Acuna Tagean Tallano and Prince Julian Macleod Tallano, whether such impediments are applicable to affect the ownership interest of the heirs of the real owners and the Tallano clans. Comments of the LRA and the Republic of the Philippines. We believe that purpose both judgment with compromise agreement between the Republic of the Philippines and the Tallanos shall hamper by legal impediments in the issuance of said reconstituted OCT, and the same should not be implemented for the issuance of both owners and duplicate copies of the original of the reconstituted land. Page 78, titles OCT number T-01-4. By the Honorable Register of Deeds of the Province of Bulacan of the following grounds: 1. There is no law authorizing the reconstitution of the lost owners and duplicate copies of tiles OCT number T-01-4, TCT number T-408 and TCT number T-498 administratively. Under the Land Registration Act Act 141, if a duplicate certificate is lost, is destroyed, a suggestion of the fact of such loss or destruction may be filed by the registered donor or other person in interest before the court of first instance of the province or city where the land is situated. In other words, the procedure should be judicial in character. 2. Assuming but not admitting that the lost owner's copy may be reconstituted administratively, we believe the same should not be given due course, because of the spurious characteristics of said title, among others, as shown here under A. Clan the Second 69, as mentioned on the face of the title, has not yet been applied for original registration, as appearing in our survey book. B. Decree number 297 covers only a parcel of land in Cavite, and not in Greater Manila area as per our records. C. That alleged derivative title, which is OCT number T-01-4, is a well-known Spanish title. D. Clan PSU 2031 mentioned at the back of the title is the same private survey number involved in the survey in the so-called Hacienda Miracaban, which supposedly covered large tract of land also in the page 79. Name of Fort William McKinley and Pedro Rojas, including portion of Taguig, Paranaki, and Pasay City, registered in the name of the Republic of the Philippines. 3. Without evaluating its authenticity, it is obvious that the proposed judgment with compromise agreement could have the same effect over the subject land, because it cannot be enforced by execution. Under the Supreme Court ruling, the land data, if any there be found, dubious the same cannot utilize for public good, because it is null and void ab initio in origin. Original signed, Antonio Noblijas, Administrator. This honorable court could not be convinced on the number one reason given by the honorable Administrator due to the fact that the issuance of reconstituted land title, particularly OCT number T-01-4, based on the judicial judgment rendered by then designated judge of the Land Registration Court, which said decision and order had been executed on October 4, 1904 in accordance with LRA 496 of 1902, clearing from it its legal impediment for the non-enforceability subsided itself, as if a bubbles in the air. Besides, the court proceedings has been conducted in accordance with the set-up jurisprudence, based on the rules of Court 132 and Rule 135, and in accordance with Section 15 of the Republic No. 26, which belies that the reconstitution is an administrative procedure. Definitely, it's a judicial in character per se. Page 80. Be reminded that incorporated to this complaint filed by the Republic of the Philippines against the landowner is quieting/reconveyance of the land covered by these titles. Therefore, it is a rule all rights of the party in interest over the land should be absolutely reconveyed to the true owner. Pertaining to spurious origin of said the second 69, PSU 2031, Decree number 297. These were also subjected into alterations, manipulation, and distortion, particularly that Decree number 297 was altered for certain Manuel Ruz y Javier, and in favor of the Maricaban estates to degrade the credibility of the Tallano and Acop over the estate's ownership, and they created a vacuum which is another basis for the land grabbers to proliferate their unlawful activities upon raping the virtue of the country's Torrens system by way of mass production of invalid land titles for continued cycles of scam to the final prejudice of the government and the general public. It was a known fact when both LRC Commissioner Antonio Noblijas and Assistant Commissioner Gregorio Bilog Jr. divulged the modus operandi of the organized syndicate in both LRC and in the Bureau of Lands then, to defeat the interest of the Heirin landowners, which were an admission of these land authority, that the eligible land records and documents of the Tallanos over OCT number T-01-4, TCT number T408, and TCT number T498 had been subjected into manipulation, alteration, and falsification orchestrated by no other than in the LRC and the Bureau of Lands in connivance by those in the Register of Deeds. Page 81. It was very apparent on what the present administration intend to do as well to our Spanish mortgage law, which is against the wisdom of Torrens system, but, of course, with the same dirty objective to the predicament of the real owners under OCT number 01-4. Besides, that said OCT number 01-4, based on this record of honorable court, it was satisfactorily established that said land title has been registered under Land Registration Act, acquired Torrens title in character after compliance with the requirements set forth in the Land Authority to issue Decree number 297 on October 3, 1904, and affirming Royal Decree 01-4 protocol embracing the entire archipelago together with its cadastral number 4720 CLRO case number 475. Beside, based on agreement, predicated by this decision with compromise agreement, 5 years prescription of enforceability of said judgment to reconstitute said OCT number T-01-4 and their TCT number T408 and TCT number T498, and eventually, to issue the reconstituted copies of its original and duplicates of said titles should be reckoned only from January 1, 1999, the period of which the Republic of the Philippines promise and commence to pay its remaining obligations amounting to P1 billion as damages to the interveners as agreed and emanated from this judgment with compromise agreement between the Republic of the Philippines and the Tallanos heirs. While Partial payment had been paid to the Tallano amounting to P2 billion pesos in the form of land bank bond certificate which will mature in 1978, but it was appealed for another 20 years moratorium ending December 31st, 1998, from which the government will, page 82, have to pay the landowner's heirs initially on 6 installment payment over that P3 billion pesos damages. My great predecessor of this noble profession taught me this judicial wisdom, and had lent me a noble judicial narration in the preservation of untainted justice involving peri materia in for immediate application of the law, and not only to one. For the truth, this court is ready to open the clandestine of those who had sown detriment to the lawful landowners. So the mighty of the Court of Justice shall be utilized as it, provided based on the authority prescribed in the revised penal code against the violators who usurp the rights of the landowners. Like in this instance case, the holder of that devoid OCT 369, its technical data were copied from the technical data of OCT number T-01-4. But the Land Registration Authority tolerates the parties by the use of such fraudulent documents like those OCT 333, OCT 730, OCT 735, OCT 291, OCT 777, OCT 614, OCT 4085, OCT 543, OCT 222, OCT 4136, and all OCT bearing number 01. Up to OCT 100,000 were found defective, defrauding the general public, and depriving as well the legitimate landowners. Based on the report of the NBI and reciprocally affirmed by two authorities in land, that said OCT 369 was declared null and void due to its non-existence, which merely derogates the authenticity of the eligible one, OCT number T-01-4. Besides, that the second 4810 to 4813 like that the second 4812 are a parcel of land situated in Berriotinumpan, Cadiz, Negros Occidental, while that the second 4813 covers the land situated in Iloilo. Besides, allegedly, said OCT. Page 83, 369 in the name of Hermogenes Rodriguez and Antonio Rodriguez, it appears that it was issued pursuant to a decision of Honorable Estel Rosario of the Court of First Instance of Resel on March 8, 1907, while that year, it should be province of Moran then, besides, in the year 1907. Jurisdiction to issue, said OCT exclusively resides in the Court of Land Registration, and only on July 1, 1914 superseding the authority of the Land Registration Court. Indeed, the Court of First Instance then in the year 1907 had not yet acquired said jurisdiction. The land title form used is Land Registration Form number 1 as could cleared from the left-hand corner of the form. Yet, the NBI investigator divulged that GLRO form number 1 in 1907 was not been introduced yet as official form on that year. That decree issued was Decree 160 not 297, since that Decree 160 was issued on March 19, 1904, and not March 8, 1904. Per record of Book of Decrees for Ordinary Land Registration Cases is Book 1. That such decree covers only one parcel of land located in Tondo, Manila with an area of 354.03 square meters only. Another OCT number 820 which is questionable in technical characteristics after confirming that said OCT allegedly have a corresponding decree referred to number 1424 embracing a land in Quezon province which was issued on January 31, 1905 which directly subsided itself after the recorded survey. Date was done on November 15, 1906, a contradictory to oneself considering that decree number had been found empty for technical description, therefore, it should be no effect. Page 84, the technical description itself which resulted on the survey conducted on November 15, 1906 turns younger later than the said decree number 1424 considering that Land Registration Act has been on its enforceability as a law. And the name of the owners, certain Patricia Shyangson, written thereon had not, in any way, applied for application for registration of the subject land. neither a free patent application had been used, which means that the origin of the land itself comes from nowhere. Connotes, these are imaginary persons in character, deserve to devoid their interest over the subject lands. That OCT number 994, in the same way, is in the name of certain Mariano Severo Tuas and Y. de la Paz, et al., with corresponding decree number 36455 was lent and adopted from TCT number 870, while on the column for the decree number written thereon was clearly empty and data ent auto. It connotes no entry in the date of decree issued, also in blank no entry. Also, as it was divulged by the NBI investigator, one OCT number 994 have two different record numbers, such as 4429 and 1559. That its expedient CTCT number 84960 in the name of Moises Bonaventure obeyed a similar decree of the same OCT, while said decree was copied from the decree of TCT 870. Its OCT is entirely different from that OCT 994. That OCT 735 is also in the name of Severo Tuas and Y. de la Paz, et al. Its original survey held on December 1910. June 1911, from which the point of reference pointed in the survey was CBM number 37. Its technical data referred to number 13 C cadastral 13. For Manila, which pointed clearly that. Page 85. Manila had started its cadastral survey only on September 1914, and was approved officially on January 3, 1916. September 9, 1916, while Cadastral Act 2259 took effect only on February 11, 1913. And the decree number 17431 of said land title was issued on July 9, 1914. This showed entirely inconsistent of its data beyond its standard chronological order, to wit, which are in contradictory to the K.O.R.A.N system. That the survey and approval should be dated earlier than its decree and its cadastral survey when intent to apply, and should be later than the Cadastral Act itself, which were enforceable after the Cadastral Act 2259 had been implemented into law on February 11, 1913. That OCT 730 again was registered in the registration book number A7 in the name of Severo Tuas and Y. de la Paz, Jose Tuas and de la Paz, et al., under decree number 7672, but the land has been found in Marikina, not in Pasig, nor in Quezon City, and neither elsewhere, the total area of which is undeminable, which is void in character. This was divulged, based on the written report of Gregorio Belog Jr., the Deputy LRC Administrator, as requested by then Honorable Solicitor General Felix Macleod in the year 1964, now, member of this highest court of the land. Corollary of this end, let traverse our judicial functions into another horizon of responsibilities as administrator of justice, not only for the deprived partner, but for the entire Filipino people, for our nation's economic breakthrough from its century-ailing and sickly society with suffering citizenry. That what involves in this scenario is, page 86, not only the government of His Excellency President Ferdinand E. Marcos, but also President Marcos himself, requiring the President to restore the missing gold reserves of the Republic of the Philippines in the designated central bank vaults, consisting of 617,500 metric tons of 12.5 gold nuggets lent and entrusted by the royal family, the Tagean Tallano clans, through the late President Manuel Rojas, in favor of the Filipino people, just to complete the requirements set forth needed in the establishment of Philippine Central Bank in the year 1949. That the said gold reserves paramountly attributed in the stability of peso value between 1949 to 1960, ranging the peso value of P2.0041 $1 to P4.00 to $1 But beyond the knowledge of the Filipino people, the basic root that caused the Marcos-Macapagal quarrel was that the unlawful acts of then Senate President Ferdinand E. Marcos, which emanated from illegal transport of some 33 metric tons of gold nuggets to London and another 77 tons to Zurich, Germany, without permission from the private owner, the royal family, the Tagean Tallano clan, and of no consent of the then President Estado Macapagal, which were taken in place all of September 23, 1963, considering that gold bullion was part and portion of the 617,500 metric tons of 12.5 gold nuggets entrusted to the national government on January 7, 1949 by the caretaker of the royal clan, Reverend Father Jose Antonio Diaz. His alias name is Colonel Severino Garcia Santaramana, for and in behalf of the Tagean Tallano royal family. Page 87. That the Reverend Father, before this court, and designated amicus curiae on May 5, 1972, he testified in an open court that he is the caretaker of around 617,500 metric tons of gold nuggets owned by the royal family, the Tagean Tallano family headed by Don Esteban Benitez Tallano, which they transported to Vatican City in the year 1939 to secure the gold bullion from the escalating World War II, and the royal family maintained it up to 1948, and was withdrawn and transported to the Philippines through the young lawyer Ferdinand E. Marcos in 1949, then. That in the presence of attorney Lorenzo Tanada, the clan's lawyer, Don Esteban Benitez Tallano and Benito Tallano, the direct owners of the said gold bullion, and in the presence of then His Excellency, late President Manuel Acuna Rojas, then La Union Congressman, Bishop Enrique C. Sobrepina Sr., the second cousin of Maria Cristina Camacho, wife of said Benito Tallano, Reverend Father Jose Antonio Diaz turned over said 617,500 old bullion which he kept long time ago under the blessings of some higher Spanish officials in a dungeon in Fort Santiago in behalf of the royal family, Prince Lacan Acuna Tagean Tallano, who went to Europe before the war, and eventually under the custody of then the old National Treasury in Intramuros, Manila, to give way for the establishment of the Central Bank of the Philippines, that the said Reverend Father, in his testimony before the court and the amicus curiae, admitted that the gold inventory intact in the central bank vaults up to page 88, the year 1964, quote, except that some 10 tons in my presence were forcibly withdrawn by the Senate Security Force led then by ex-Senate President Ferdinand E. Marcos, now President of this Republic, on September 8, 1963, and had transported to nowhere. That said Reverend Father was the one who gave idea to His Excellency President Ferdinand E. Marcos to undertake the illegal withdrawal of the said gold bullion from the central bank vaults on the sense that Don Esteban Benitez Tallano, heirs of the late Prince Julian Macleod Tallano, owner of the said big bullion consisting of 617,500 metric tons, died in Europe during the American occupation in 1898. And the Reverend Father alleged the heir Don Esteban Benitez Tallano died also during the Japanese time, yet the asset left with no will and no legitimate heir, in spite of the fact that the truth was that the late prince has a last will and testament entrusted to the custody of Reverend Father Jose Antonio Diaz, clarifying that he has surviving heirs, Don Esteban Benitez Tallano, Benito Tallano, and the only son of Benito Tallano, Julian Morden Tallano, who also inherited the title of prince, bestowed upon him by the royal family in accordance with the Code of K.O.R.A.N, inasmuch as although he has a 50% British blood, his ancestors were Muslim British lords. That said Prince Julian Morden Tallano has been authorized to administer, and, when necessary, withdraw the said assets deposited in the central bank vaults and all gold bullion deposited in Fort Knox, and in Zurich, and in other countries, that served as trustee of His Excellency Ferdinand E. Marcos, and he is, page 89, entitled to collect the 5% of the 1% royalty fee of the national government starting from the year 1965, the unpaid period of the government, inasmuch as since 1949 to 1964 the government had fully complied the royalty fee. That the Reverend Father also admitted that the only gold bullion balance left in the central bank vaults are consisting of 400,000 metric tons, others, some 217,500 metric tons between 1965 to 1970, were illegally melted into another form of 75 kilos per bar, and were transported to different countries in Red China, Hong Kong, Switzerland, Germany, Australia, USA, and in England. Here is the excerpt from the testimonies of Reverend Father Jose Antonio Diaz, alias Colonel Severino Santaramana, taken in an open courtroom on 10:35 a.m. of May 5, 1972, before this court and amicus curiae. Attorney Cesar Parras Sr., With your permission, Your Honor, supplemental to my cross-examination to Reverend Father Jose Antonio Diaz, vital witness in connection with the illegal transport of said gold bullion of my client, the royal family, Tagean Tallano clan, which caused the sudden collapse of the value of Philippine peso. May I ask some important questions, Your Honor, relevant to the sworn? Page 90, affidavit executed before a notary public. Court. Yes, you may, provided the questions are relevant to the subject matter. Amicus curiae. What is the purpose? Attorney says a parasenia. Yes, Your Honor. To clarify matters in accordance with missing gold reserves. Attorney says a parasenia. Do you own this typewritten sworn affidavit? Reverend witness, and how did you come to know about the illegal transport of the deposited gold bullion from the central bank vaults and that of its exact date? Witness Reverend Father Jose Antonio Diaz, I was the one who signed this affidavit, sir, and being the caretaker of the royal family, I was the authorized signatory for the withdrawal of that deposited gold bullion from the central bank vaults, and I used it to withdraw the same, as instructed to me by then Honorable Senate President Ferdinand E. Marcos on September 8, 1963. Besides, I was the one who, page 91, accompanied Don Esteban Benitez Tallano in transporting the said gold bullion around 617,000 metric tons to Vatican City, Your Honor, sometime in 1939, to protect the item from the fast escalating World War II. Then, Your Honor, attorney says a parasenia. How many kilos did you withdraw that time? Witness Reverend Father Jose Antonio Diaz, based on my arrangement with then Senate President Marcos, we will withdraw only 3 tons or 3,000 kilos. But when I and Senate President Marcos were already in the central bank vaults, Central Bank Governor Andres Castillo and Senator Marcos convinced me to sign the withdrawal document containing 35,000 tons that time. I have no choice but to sign. Attorney says a parasenia. Reverend witness, after signing the withdrawal document you mentioned, what transpired next? Witness Reverend Father Jose Antonio Diaz, right at that moment, Senator Marcos withdrew the gold bullion from the vault, and loaded these on 4 trailer trucks escorted by, page 92, Philippine Army member led by an unknown colonel and 4 members of the Philippine Constabulary, and were driven toward the departure area of the Manila International Airport. Then, sir, attorney says a parasenia. Reverend witness, when you were in the Maya departure area, what follows next? Witness Reverend Father Jose Antonio Diaz, I witnessed the unloading of the gold from the trailers, sir, which were packed in 70 pieces of wooden crates, and they loaded these in the belly of the KLM airline that time. Attorney says a parasenia. Reverend witness, you said you were there when the repacking of the gold had been done. How long did it take? Witness Reverend Father Jose Antonio Diaz, because when we arrived in the central bank, the time was 8:00 o'clock in the morning. When they finished packaging and loading to the trailers, the time was 3:00 o'clock in the afternoon, so approximately, sir, it took 7 hours long when we finished. Page 93, attorney says a parasenia, being the caretaker of the Tallano Tagean family's gold bullion, can you tell to this honorable court how many, and what is the exact number of kilos do the Tagean Tallano family had deposited in the vaults of the central bank? Witness Reverend Father Jose Antonio Diaz, exactly around 617,000 metric tons, that the Tagean Tallano had deposited to the vault through me in the year 1949, which we transported from the Vatican City in the year 1948. The same were lent to the national government to meet the required gold reserves of the newly organized and installed central bank then. But lately, when I went to the central bank along with the heirs, Don Esteban Benitez Tallano and Prince Julian Morden Tallano, for verification and inventory recently, we found that the only exact inventory remained intact in the vault then was 400,000 metric tons, while what I withdrew that time beyond the knowledge of the owner through instruction of then Senate President Marcos, now President of this Republic, was 35,000 metric tons. Page 94, leaving a supposed inventory balance of 482,500 metric tons, but this was inconsistent to our findings, where the last inventory balance was only 400,000 metric tons. Definitely, sir, they used fraudulently my signature, to withdraw such 82,500 metric tons. Solicitor Gutierrez, Your Honor, I wish to call the attention of the Honorable Court to strike the words as follows, but this was inconsistent to our findings, where the last inventory balance was only 400,000 metric tons. Definitely, so, they used fraudulently my signature to withdraw such 82,500 metric tons. Amicus Curiae, for what purpose? Solicitor Gutierrez, the answer of the witness was not responsive to the question propounded by the counsel. Beside, his statement about the withdrawal of 82,500 metric tons is merely moron hearsay, because he was not there when the alleged withdrawal of 82,500 metric tons took place. Page 95. Attorney says a parasenia. Objection. Your Honor, the witness has the right opinion which is valid, based on his authority, designated to him by my client, that he is the only person that has an authority to withdraw said gold bullion deposits. Court, alright, just maintain the record. Eventually, we will cross the bridge when needed. Enough over such testimonies that we can no longer deny the veracity of the Reverend Father's statement, and inasmuch as no opposition from the government, except they signified their conformity, to issue this decision with compromise agreement between the Republic of the Philippines represented by His Excellency President Ferdinand E. Marcos and his Solicitor General, and by the party in interest, Mr. Benito A. Tallano and his son, Prince Julian Morden Tallano, represented by their legal counsel. Attorney says a parasenia. Let's go back to other subject matter about the land, that a land registration court proceeding is an action and rem. Therefore, the decree of registration, after it has been issued to the party in interest, binds upon and conclusive against all persons of any nature including this government, the Republic of the Philippines and its branches, agencies and instrumentalities, regardless or not they were notified of the filing of application intended for registration, or neither or have appeared and filed for the corresponding answer against such application, because, as a rule all. Page 96. Parties in interest are considered as notified by the publication required by the law. This case was strongly cited in Sorsogon and others versus Macleod et al. 45 OG 9, 3819. September 1949, when the royal family, the Tagean Tallano clan, maintains their position that their land title, after it was published in the Gaceta de Manila sometime in March 14, 1902 under the operation of K.O.R.A.N system in accord with LRA 496 of 1902, their OCT number 01-4 which was issued in the year 1764 with the decree of registration turned conclusive, because such decree of registration once became final, could not be subjected for attack by any person either by reason of minor age of the co-owner, neither would there be found credible in the allegations that the decreed persons, claiming as owners, held the property in trust, or as co-heirs, when they filed their application for registration and correspondingly obtained registration in their names, without opposition, upon establishing factual information their predecessors had been open as owners, and in what capacity they gained the same, which is true in a case of Gonzaga et al. Versus Guanzon et al. 68 Phil 351, 1939. Similarly, this court cannot sustain the defense of the national government, the heirs of Hermogenes Rodriguez, the heirs of Mariano Severo Tuazon and the Tuazon Company, including the defense of the Ortigas and Company, that they were not around as party in interest when the decree of registration over the same subject land had been conducted in proceedings, since in the rule of registration, decree of registration could not be reopened by reasons of absence. Page 97. Minority or by reason of disability of any person adversely affected by said decree of registration, not even by any proceeding in any court, like this for instance, for reversing such judgment, but may be subjected, nevertheless, to every right of any person including the government and its branches thereof, their interest had been deprived by actual fraud, should be filed in the court of origin or any court of competent jurisdiction within 1 year after the entry of such decree instituted as registered, which patently true in a case of CRUZ versus Delval, 55 OGP 9901, November 23, 1952, CA, Samant et al. Versus Descala et al. 107 Phil 198, 1960. In the case at bar, both the national government and the herein oppositors failed, and neither its government instrumentalities and agencies had filed their petition for review after the decree of registration number 297 for the legalization of OCT 01-4, in accordance with the Land Registration Act 496, had been registered on October 4, 1904. Which said OCT 01-4 and its decree of registration becomes incontrovertible. This case is a petition for the reconstitution of OCT 01-4 with annulment of all the titles described in a certification issued by the Administrator of the Land Registration Commission, Honorable Antonio Noblihis, and with reconveyance of the subject land which are in the possession of the heirs of the late Prince Julian Macleod Tallano, filed by the national government through its Solicitor General, Felix Mercasia, which the national government had. Page 98, complied with the jurisdictional requirements enforced by Republic Act No. 26 and Circular No. 47 of February 19, 1949, but to no avail. One more time, the national government lacks stronger evidences against the true owner, the Tagean Tallano clan. What the evidences the government had used and presented were those documents and OCT 01-4 in the name of the late Prince Lacan Acuna Tagean Tallano. On strong confidence the late prince have no issue, neither has surviving heirs. Such action of the government is only proper under the principle of public domain against the oppositor claimants, who have also stronger evidences and titles through these were issued in the name of Prince Lacan Acuna Tagean Tallano, then eventually to the late Prince Julian Macleod Tallano in the year 1864, which was affirmed in accordance with the Land Registration Act 496 of the year 1902. And parenthetically, the same was re-adjudicated in accordance with Cadastral Act of 2259 on March 14, 1914. While the land title of the oppositors other claimants were issued only in the later year of 1902, some in the year 1906, some in the year 1914, 1926, etc. Except the OCT 369 of the Hermogenes Rodriguez, which has been allegedly in the year 1864, 1888, 1896 and 1892, but it becomes the subject of this ruling against said OCT 369. Which its decree was found fraudulently defective in character as it were divulged in this context. Apparently, the national government failed to refute the existence of the lawful heirs of the late Prince Lacan Tagean and Prince Julian Macleod Tallano on the mere fact. Page 99. That some of these heirs became instrumental in the establishment of Central Bank of the Philippines in the year 1949 after Don Esteban Benitez Tallano, accompanied by Reverend Father Jose Antonio Diaz through the efforts of brilliant lawyer attorney Ferdinand E. Marcos, had transported the gold bullion from Vatican City which were used by the late President Manuel Rojas, cousin of Don Esteban Benitez Tallano, as gold reserves requirements. This information do not intend to complicate the issue, but are sound proof as to the existence of the heirs of the late prince, that the government cannot deny, but rather it compel to be guilt of Esteban which was raised by the surviving heirs. Truly, the Republic of the Philippines had committed Esteban, and had rebound to become not party in interest over the subject land in the presence of surviving lawful heirs. Occasionally, it must be obliged for reconveyance for all the lands under its custody as illegal detainees, or in graceful census trustee, for which it requires a reconveyance in favor of its principal or truster, as prescribed by Civil Code of the Philippines. The fundamental rule over this issue, after the registered land had lapsed for 1 year, a decree of registration can no longer be opened for review, even if its issuance is attended by actual fraud which the government failed to file said basic action. And the chances of the government to open as an aggrieved party remains an open opportunity considering the land had not been passed to. Page 100, innocent purchaser for value, yet, an action for reconveyance still available that reached to this case against the Tagean Tallano clan, but still the Republic of the Philippines failed to solidly and constructively establish its interest over the land. Under these circumstances, the true owner asserted his ownership and title to the land, and this court cannot neglect its paramount duty to exercise its power for equity and justice, so correspondingly, an urgent court order to cancel the involved land titled of other land claimants, including the title used by the Republic of the Philippines, in order to direct other unlawful owners in that Republic of the Philippines to reconvey the land holdings under their custody, or as trust, is inevitable to the rightful owner. The rules and order of reconveyance is just, equitable and imperative, the only course of action in the court, to eradicate the unmanageable evil and anomaly in the LRC, and in the Register of Deeds, where the lawful registered owner should have a holder of Torrens title for the land they acquired by their own labors, sweat and exerted efforts for quite so long, but they and their predecessors could not exploit it, because it is possessed by ineligible parties under the concept of ownership. To hold such land beyond the true and lawful orders of land ownership in greater sense would vindicate only the land grabber for glory, directly a dismay to the moral value in human relations, that no person shall unjustly enrich himself at the expense of eligible one. Page 101. To supplement the issue, there must be annulment for those titles that has been reported fraudulent in character, to prevent the general public from further damage, or worst as it may be. So it would not be precluded for the annulment filed by the Republic of the Philippines, that the oppositors had asserted its rights beyond possibility by reason of simple possession of registered certificate of titles, which said reason is not within the ambit of the law in the Torrens system, because, to the contrary, the Supreme Court cited the incident in a case Vital vs. Anor, and others, 1952. That any free patent or subsequent title issued pursuant thereto is null and void ab initio. Because on the other hand, an adverse owner of a registered land undisturbed in his possession thereon for a period of more than 50 years, and without any knowledge that the same subject land he actually tilled and occupied has been registered in the name of another person, is not barred from filing an action for reconveyance, which, in effect, the herein true owner had sought the assistance of this court under this proceeding, considering the owner is the adverse respondent to the case at bar, so he seeks a reconveyance, and quieting the aforementioned titles of the subject land, who was, being the lawful owner, so confident relying upon a Torrens title which could have fraudulently issued by wrong claimant. Similarly, actions for reconveyance complained against the national government by reason of null and void ab initio principle, for a claim of prescription on the action by the national government and other oppositors would be unavailing, which was affirmed in a case Ann vs. Director of Lands, supraciting Laguna vs. Laventino, 1941. Page 102, 71 Phil 566, Corpus, et al. Versus Beltran, et al. A 955, 97 Phil 722. Furthermore, whereas the herein respondent lawful landowner holder of Torrens tile who has been in possession of the subject land in dispute, his action to quiet the aforesaid titles against the government and other parties is imprescriptible in nature. Balade vs. Castillo, et al., 1961, Scra 1064, Villanueva, et al. Versus Portigo, et al., 1969, 29, Scra 99, Ramirez vs. Court of Appeals, et al., 1969, 30 Scra 297. On the issue of laches as a defense of the Ortegas and Company against the Tallanos, jointly augmented by its correspondents and other party in interest, led by Honorable Solicitor General, Tuason and Company, Incorporated Bonifacio Regalado, the heirs of attorney Gregorio and Salvador Aranita, the Ayala Corporation, the Pillar Village Corporation, Don Hermogenes Reyes Rodriguez and heirs, the group of Manny Villa and Company, Don Mariano San Pedro and heirs, the Piedad Estate, the heirs of Pedro Rojas, the heirs of Patricia Chiangson, the Tiburcio Estate and heirs, the heirs of Antonio Fiel, the heirs of Pedro and Salvador Leas, the claimants of Pasay and Miracaban Estate, the heirs of Fernando Jacinto, the Jacinto Steel Mills, Dr. Nicanor Jacinto, et al., the heirs of Jose Dimsum, the heirs of Eulogio Ragua and Company, the heirs of Almeida and Company, Teodoro Lim and Felix Bees, the heirs of Agapito Bonson, the administrator of proposed Bacute and Santo Pacial Market, the heirs of Dominada de Ocampo Buhain, the heirs of Pedro Ann. Page 103, Antonio Cruz, the heirs of Ponciano Padilla, the heirs of Fortunato, Ricardo and Maria Pantaleona Santiago, the heirs of Sebastian Fajardo, the administrator of npQuHA and claimants in the person of Don Fac. Undo, the heirs of Donia Lourdes Ochoa y Casal, the heirs of Antonio Aquiel, the heirs of Julian and Juan Francisco, the heirs of Santiago Garcia and Company, the heirs of Donia Aurora Fabula y Cordona and Company, the heirs of Mayor Feliman Aguilar of Las Pinas Municipal Hall, the heirs and administrator of Sereo Motors Corporation and Francisco Motors Corporation, the heirs and administrator of Goodyear Tire Rubber Company, the heirs and administrator of Philippine Shares Company, the administrator of Manila Railroad Company, the administrator of Pangasin and Transport and Company Pantranco situated in Francisco del Monte, the administrator of Fort William McKinley, the People Home and Housing Corporation, affiliated to the National Development Corporation under the pretext of newly proposed name of National Housing Authority, the Commission of the Bureau of Lands and Forestry, the administrator/director of the Land Registration Commission, and, for fairness to all, is a defense that could not be ignored if banking to the doctrine of stale demand, an offshoot of the law of laches, which is based upon the very foundation of sound public policy, a prerequisite to attain peaceful society. It is the direct diffusion of stale claims, unlike the statute of limitations, is not merely a problem of time, but principally by reason of the inequity or unreasonable acts allowing still a right to enforce claims which lapsed by reason of abandoning for a long period of time. Particularly this time, where page 104, aforementioned respondents and oppositors against the Tagean Tallano heirs had many times introduced their improvements and fencing over the areas where hundreds of commercial buildings, privately and publicly, including residential subdivisions and villages, were erected thereon, which such circumstances the defense of laches is highly appreciable on the reason of unmanageable money cost on the part of the developers and national government, if the Tallano Tagean heirs have ignored, or had never protested such improvements which construed that they are tolerant for a long years, yet, it had to prevent that laches have never constituted, thus, ultimately barred the original owners from recovering the possession over the titled land by virtue of laches, which is very true in a case. Mejia vs. Gamponia, 100 Phil 277, 1956, Miguel vs. Catalano, 26 Scra 2234, 1968. On the other way around, the Tagean Tallano heirs strongly manifested that they did not abandon their possession over the titled land. They presented strong evidences that their action for absolute ownership and possession over the subject lands never ends, and borne out by historic judicial records which are chronologically stated among other things as follows. 1. Since 13th century, the land, called before Mahalaca, now Philippines, has a territorial area of 1,049,212.169 square nautical miles with a total geographical area of 169,972,500 hectares of plains, mountains, forests, rivers, and seas. More or less, it embraced 4 major page 105 islands for a total of 7,169 islands, the Luzon Peninsula, the Palawan Peninsula, the Visayas Peninsula, and the Mindanao Peninsula, in habitation of King Luosan Tagean, the predecessors of the Tallano Tagean heirs, who was being respected by the Chinese traders and emperors, by paying tribute to the said king in the form of silk cloths, precious stones, and tons of gold. 2. Due to economic abundance in the islands, Ferdinand Magellan, a Portuguese, sent a mission to explore the possible sources of species with simultaneous propagation of Christianism, but with arrogance and envious to the abundant resources of the archipelago beyond the knowledge of King Philip II. By force he conquered the island where bloody battle in Mactan had risen as defended by the king's eldest son, Rajalapurapu, in the year 1521. 3. The invasion escalated to Manila province then, where the second eldest son, in 1571, named Raja Soliman, fought for the defense of the area, but due to overwhelming arms and ammunitions of the invading Spanish imperial armies, the second eldest son escaped to the forested area of Kirilaya Island, then, now province of Quezon, for, by the influence of the King Luosan Tagean Tallano, he complained to the Holy See about the abusive land grabbing of friars in the Philippines. the complaint had been heeded. So, by the papal grant of page 106, the Patronato Real in the late 15th and early 16th century, the Spanish royal crown tried to succeed to have most complete control over the churches in the Indies, including the Philippines. The result of which was the dissolution of the religious orders in the year 1836 and the confiscation of the church properties, and the continued existence of the religious orders in the Philippines was totally dependent on the political endeavors of the government of the Royal Crown of Spain, that has a little trust and faith in their religious missions on the account that the friars have no control of. Abuses, where compassion that is supposed to be instituted for the sake of human lives, and private properties most of the time were violated by the churches in the Philippines. Spanish Mestizo Filipino friars hold biggest area of the subject land by way of converting into several haciendas into their names. That gave rise to the Order of the Royal Crown that Spanish Mestizo Filipino friars and its clergy were subject to be observed on as potential danger, and so the Royal Crown moves more and more in the direction of annulling their influence as response to King Luis ang Tagean. In this account, the Spanish Mestizo Filipino friars were determined to their self-interest, land-grabbing agenda by implicating the case against native Filipino priests, who were in possessions for the Tagean clan's objective, toward their political aspect of secularization, which furtherly emphasized this aspect in their effort to influence government policy in the page 107, pretext of the matter of secularization, to push through for the security of the subject lands, the whole archipelago in particularly. This is a direct transcript of the testimony of the friar provincial before the Philippine Commission and the U.S. Senate, over the land held for ecclesiastical or religious uses in the Philippine Islands. Document number 190, 56th U.S. Congress, 2nd Session, 1901-5. In that aforesaid area of Kiralaya, Raja Soliman married Princess Dayang Kiram, and gave birth to their only son Lacan Tagean, who survived out of 18 children they were born. Raja Soliman died in that very birth date of the 18th son at the age of 169 years old. Prince Lacan Tagean at the age of 40 had married to Princess Rowena Maria Elizabeth Overbeck Macleod of Austria, who sought for a succor of British Royal Army by the order of King George III of the Royal Crown of Spain, on the 7th day of January, 1764. The said OCT 01-4 had been issued in the name of Prince Lacan Acuna Tagean, who inherited the title of the King Luis ang Tagean, right after the liberation of the islands by the British Royal Crown from the abusive Spanish conquistadors. 6. After the King Lacan Tagean died 100 years after the said title OCT 01-4 had been issued in his name, he was succeeded by his 16 years old son, Prince Julian Macleod. Page 108. Tallano in 1864, who was born on December 17, 1848, where, again, the Tagean Tallano encountered court challenge anew involving the same subject land lodged by the encomenderos, Don Hermogenes R. Rodriguez in the year 1864, alleging before the royal audiencia under the case RD 571, that the said land had been a reward to them by the Royal Crown of Spain in honor of their grandfather, Governor Miguel Lopez de Legazpi Rodriguez, who pacified civil war in Mindanao. But after 16 years of court battle in the court of royal audiencia, the Prince Julian Macleod Tagean Tallano has ownership interest over the archipelago, had regained the title of ownership anew over the said island in the year 1864, by virtue of the order of the Royal Crown of Spain under Royal Decree 1864, controverting the issues of land grabbing against the Royal Crown for the main reason that the only objective of the expedition of the Royal Crown to the island of Mahalaca, now Philippines, is propagation of Christianism, to rectify the lives of the inhabitants with glorious affiliation to the Divine Supreme Being, the God the Father, and not to conquest the Mahalaca Kingdom. 7. The final decision of the 1864 Royal Decree of the Royal Crown reverting the land ownership to the royal family, the Tagean Tallano clan, gave rise to different strategic land grabbing by the Filipino-Spanish mestizo that drove again the Mahalaca Kingdom to massive wars in the form of rebellions by the king's descendants. Page 109. 8. Before the death of Prince Julian Macleod Tallano Tagean in 1898, he succeeded to win the support of the Grand Government of the United States of America, where the Treaty of Paris between Spain, United States, Great Britain, France, and Germany had been signed and enforced into law, respecting private ownership of the inhabitants and the royal family of the archipelago. The prince died on the year 1939 at the age of 91 years old by reason of heart attack in Europe, after he transported the Tagean gold bullion of 617,500 metric tons to the Vatican City, and had deposited it to the trust of the Holy See, as escorted by Reverend Father Robert Hayes, who was in custody of the last will and testament involving OCT 01-4 of the archipelago and that precious wealth, whose heirs are Don Esteban Benitez Tallano and Benito Tallano. 9. Land grabbers Filipino mestizo headed by attorney Gregorio Araneta, former lawyer of Don Esteban Benitez Tallano, pushed their evil intent over the subject land by lobbying in the United States Congress for the issuance of Harvey Harding Cutting Law, HHC, a law attempting the exclusion of foreign land holdings in the islands in pretext of American military reservation rights. But again, said moves had not been prospered through the intervention of the lawyer of the royal family, attorney Eugenio Benitez, the cousin of Don Esteban Benitez Tallano, and by another lawyers, attorney Benito Legada and attorney Claudio Gabriel and Francisco Ortigas, and attorney senior Modesto Reyes, assisted by another 2 lawyers of the page 110 family, attorney senior Pablo Acampo and attorney senior Pedro Sotero Laurel, that caused a route for a massive protest of the Filipino legislators turning down said repressive laws. 10. Attorney Gregorio Araneta succeeded to be reunited with attorney senior Francisco Ortigas and other family lawyers of the clan, and had availed for the passage of another despotic law, the Land Registration Act 496 of 1902, but again the oppositors failed to adulterate the land area of OCT number 01-4 and finally, failed to oppose royal family ownership interest, but it only strengthened the very foundation of the royal family after successfully obtaining the affirmation of land registration court, then CLR case number 475 by the issuance of Decree 297 on October 3, 1904, again in the name of the late Prince Lacan Acuna Tagean and Prince Julian Macleod Tallano Tagean, who died on December 17, 1939. 11. Evil intent to land grab the same land had never ceased. The same oppositors lodged and lobbied for the passage of another repressive law under the guise of Cadastral Act 2259. Court battle again in the cadastral court ended on March 14, 1914, respecting ownership in favor of the Tagean Tallano clan by allowing for the issuance of segregated title under TCT number T408 and TCT number T498, which was manifested victory for the Tallano in court battles. Record by the financial support of Don Juan Ejército against the oppositions, that caused the approved plan of the entire archipelago under Plan the Second 69 in the name of Prince Julian Macleod Tallano. Page 111. 12. After the war, between 1948 to 1956, beyond the knowledge of the clan, all supporting ownership evidence is compiled in the Register of Deeds of the Province of Manila, City of Manila now, and in the Province of Rizal, together those in the Bureau of Archives, including the plan of PSU 20131, the second 69, Gaceta de Manila, were reported vanished and followed by successfully alteration by the heirs of the same oppositors in conspiracy of the administrator and officers of the Rural Progress Administration, now the LRC, by those in the PHHC and those in the Registry of Deeds and those in the Bureau of Archives, which divulged that around 500,000 historical documents, including those ownership evidences over the subject lands, were disappeared from the records, if not directly stolen by those who have vested interest sometime in 1956, that gave birth to the raising of the cancelled OCT 369 in the name of Don Hermogenes Rodriguez, a new which was manipulated also even the record of Gaceta de Manila, followed by that OCT 4136 in the name of Don Mariano San Pedro, who became Steward o Don Esteban Benitez Tallano, OCT 779 in the name of Domingo Acampo, the nearest kin of attorney Senior Pablo Acampo, the old-time legal counsel of the Tallano Tagean royal clan. also follows the manipulations escalated to massive frauds that gave rise to the issuance of 100,000 fake land titles in OCT from OCT 01 up to OCT 100,000 intended to defeat the original land title of the true owners, OCT 01-4. Which were scattered to many prominent names of known businessmen and developers in conspiracy by those in the government, both. Page 112, national and local, that given birth to other claimants like late Agapito Bonson whose OCT 40,875 had been issued, which connotes that former delegate of the Malolos Constitution who died before World War II had rose from his grave to be able to register his land holdings OCT 4085 in the year 1964, 13. That in the later part of 1962, a vaudeville court proceedings between the PHHC, represented by the Office of the Solicitor General for, and in behalf of the Republic of the Philippines under LRC/Civil Case number 997P in CFI Branch 28. Pasig City, born in the open, Eulalio Ragua, the holder of OCT 632, and the heirs of Mariano Severo Tuazon and the J.M. Tuazon and Company Incorporated, the holder of OCT 735, both titles embracing 4,399,322 square meters in Quezon, Quezon City, now Diliman, Quezon City, where different interest like the Quezon City Hall, Philippine Science High School, Quezon Memorial Circle, Visayas Avenue, the Quezon Memorial Park and Wildlife, the Up Village ongoing project, the East Triangle and West Triangle where the Film Homes has been situated, the ongoing Project 6 housing project, the ongoing Vasha Village, the U.S. Veterans Memorial Hospital, the Department of Agriculture and Commerce, the Bureau of Land and Forestry, the Philippine Sugar Regulatory Commission, the General Auditing Office, the Philippine Virginia Tobacco Administration, the Department of Transportation and Telecommunication, the UP Building, the newly developed Pag-asa Village, the San Francisco Elementary School, the Philippine Veterans Village in the Project 7, the ongoing Mindanao Subdivision, the page 113, Bago Bangtay Resettlement Housing Project, and 4th and 5th of the North Triangle of the Phil-Am Life Home Housing Project, particularly in the person of Eulalio Ragua, had been able to file similar complaint over the same subject matters against the government cohorts in the said Moro proceedings in the RTC of Quezon City under civil case number 119, considering they are party in interest in this proceedings under LRC/civil case number 997, since 1962, which was consolidated under LRC/civil case number 3957P by the motion of the Solicitor General, now under CFI Branch 28. Pasay City, on the ground that in this sala has fewer cases pending, and like in the sala of the CFI in the province of Rizal in Pasig has a tremendous big backload of both civil and criminal cases that may reach 2 centuries before the case have reached into judgment. If not these, some other cases, like the case at bar, will not be heard in this sala. 14. Correspondingly, the Honorable Solicitor General Felix Macleod had enabled to gain court resolution by way of his motion filed in the said Quezon City CFI, stopping the said CFI judge to hear the civil case number 100-119 to prevent the illicit exploitation of Philippine judicial system for personal whims and duplicity of court action and decision that may estope the interest of the national government, inasmuch as those respondent plaintiffs and oppositors are persons of the nature and interest with the same identities, who have the same subject matters under this LRC/civil case number 997, now LRC/civil case 3957P. The suspension over the proceeding under page 114, civil case number 100-119, responsive to the petitions of the Honorable Solicitor General, had been granted by the said CFI court in Quezon City, then. Along this line, in the above stated case, this court can consider that Tallano Tagean legal action never rested, as manifested by LRC/civil case number 997 later 3957P in the monumental historic circumstances aforementioned, where the relentless effort of the lawful owners, the Tagean Tallano, have stretched their effort for more than 4 centuries of struggles in defending their sacred lands, not only for the clans, but their noble ends is for the entire Filipino people towards sound and stable economic prosperity of the country, yet, disregarding the issue of abandoning their interest over the land that drive the concept, the original landowner became tolerant for quite some time, opening the Pandora's box to attain the constituted laches. Indeed, delaying asserting one's right before a court of justice to recover his possession and ownership over the land is strongly inadmissible for lack of merit of his claim, since it is clearly a human nature for a person to be timid to enforce his right when the same is coerced and threatened or invaded by excessive influential force and abusive authority in this government of selected few. Thus, he has never stopped by laches from questioning the ownership of the land in question. More specifically now where the city of Manila and its suburbs are under siege of military men of this administration, to advance the interest of their cohorts in the real estate industry over the forthcoming suspension of the writ of habeas corpus. Very clearly, a title once. Page 115. Registered under the K.O.R.A.N system of land registration cannot be defeated, even by adverse, open, and notorious possession or by laches. By tradition, registered title under the K.O.R.A.N system cannot be defeated by prescription. It is a universal acceptance. The title of the land once registered under the K.O.R.A.N system is sufficient notice to the whole world, because such action is an action and rem. All concerned, including the government and its agencies, should take notice of this rule, that no one can plead by reason of ignorance of registration. What many times the law had declared, and by the opinion of known luminaries and judge of Philippine courts in regard to the acquisition of title to real property by adverse possession, is not applicable to the land. Its true owners never resisted to assert their ownership over the land, equipped with registered land title under the K.O.R.A.N system in consonance with the provisions of the Land Registration Act 496. Which clearly cited in a case, Corporation D. Pages Augustinus vs. Crisostomo, 32 Phil 427, 1915. The law have admittedly say that not even the national government may acquire the land in question, owned by private person by way of prescription, even if to the extent of taking the land for roads and highways or infrastructures by reason of eminent domain, the title thereof could not be transferred to the government, which held under the case of Heir vs. Auditor General 102, Phil 875, 1958, and in Alfonso vs. Pasay City Government, 106, Phil 1017, 1960, that such registered property cannot be lost to the government by prescription and the owner is entitled to be page 116, paid of the price thereof as prescribed by our 1935 Constitution Section 2 of Article 3 Bill of Rights. Even if the prescription law over the registered land under K.O.R.A.N system cannot guarantee it all from evil attempts, still this court remain proudly believe on its uncowed determination and judgment, that the rule must stand vigorously against anyone, nevertheless how painful it may seem, for the sake of sound stability of our land registration system, and for sound judicial system. Let us face and fight nevertheless such abusive laws, unlawful conducts and acts orchestrated by the oligarch government leaders of this generation. We maintain the doctrine that the registered owner under the K.O.R.A.N system has an absolute right to recover possession of the registered property as highly equally imprescriptible, while possession over the land is only a consequence of ownership. Thereby, it should be likewise unavailing against the latter's hereditary successors, because actually they merely step into the shoes of the decedent by operation of the law. C. Stun, et al. Versus Nunes, et al. 97 Phil 762, 1955. Today, in this circumstances, and in the case at bar, could not be given due consideration as a valid defense of the herein oppositors, and not even the government for claiming ownership of the same subject land which has been registered in the name of Tallano Tagean under the K.O.R.A.N system for quite some time, for 70 years now, that prescription will not lie upon, neither that laches could be regarded, and make available as lawful defense, which was page 117. Furtherly clarified in a case, De La Cruz vs. De La Cruz, CAN-G point on number 18060 R August 30th, 1950, wherefore, in view of the motion for the resolution of separate decision with compromise agreement as submitted by the Republic of the Philippines through its Honorable Solicitor General, the same has been granted, and both owner and duplicate copies of the lost original of OCT number T-01-4 has been considered reconstituted with the same force and effect for, and in favor of the heirs of Prince Lacan Acuna Tagean Tallano and or his successor in interest, subject to the following terms and conditions as herein stipulated by both proponents, here namely, 1. That the Republic of the Philippines through its then President, His Excellency Dr. Estado Macapagal, along with his then Honorable Secretary of Justice Salvador Merino, and now had adopted by His Excellency President Ferdinand E. Marcos along with his Solicitor General, representing as legal counsel of the Republic of the Philippines waived its right over the land that has been presently found public land or titled land, but from fraudulent source or fraudulent in character to and in favor of the heir of the late Prince Julian Macleod Tallano, or to his heir or his successor in interest, Prince Julian Morden Tallano, on the conditions that the land emancipated to the farmers beneficiaries of the government land reform program should be recognized and well respected, free from any taint or maneuver of illegality or conversion of any party whatsoever into page 118, commercial or other purposes than the objectives of the land reform program. The said subject land, otherwise in case of breach over the conditions, should be recalled to and in favor of the owner, Tagean Tallano clan to secure the interest of the Filipino farmer beneficiaries. 2. That all land covered by agricultural land reform should be preserved for the interest of the farmers, and of the government, and only unpaid payments due to the landowner out of the expropriation proceedings should be paid to the eligible beneficiaries, the heirs of the late Prince Julian Macleod Tallano. 3. That all lands occupied by government structures, either national or local, the same should be saved for the interest of public domain in the form of donation. 4. That all lands reserved for national parks, hospital and military camps prior, under and after the administration of His Excellency Ferdinand E. Marcos, the same should be conserved, except when subject properties would be subjected to a commercial use. Said land should be reverted to the lawful owner, the Tagean Tallano clan. 5. That the government should extend authority firmly and its cooperation to the herein lawful owner, in pursuing their claims to Sabah and Tagean Calayan Islands to the extent of seeking from the jurisdiction of the International Court of Justice, in order to secure our page 119, national interest and sovereignty against eventually or invasion. 6. That the government, national or local, should conserve environmental interest of the archipelago by instilling an appropriate law and ordinance. Otherwise, when failed, the lawful heirs have the rights to pursue the same by putting up restrictions for prevention of hazard to the affected areas, either the sea, forest, rivers, mountains, or valleys. 7. That the lawful heirs have the right to recall the land designated to the farmers, or intended beneficiaries when said paramount purpose of the government defies, or virtually diverted into a commercial interest for its cohorts, and or only when said land reform and urban land reform for the benefits of other party or parties other than those beneficiaries, the Filipino farmers. 8. Ordering the Honorable Register of Deeds of the towns, cities, and provinces where the land is located and or directly the Honorable Register of Deeds of the Province of Resol, Honorable Register of Deeds of Pasay, Honorable Register of Deeds of Manila, to adopt the reconstituted owner and duplicate copies of the land title OCT number T-01-4 in the issuance of expediency TCTS4, and in favor, and in behalf of the late Prince Lacan Acuna Tagean Tallano and his heirs and assigns, including the issuance of expediency titles, to protect the Filipino people under the K.O.R.A.N system law. Page 129. Ordering the National Government, Office of the President of the Philippines and his staffs, the National Treasurer and his staffs, the Solicitor General and his staffs, and the Governor of the Central Bank, to relocate the remaining inventory balance of 400,000 metric tons of gold nuggets owned by the royal family, the Tagean Tallano family, and, when relocated, return the same to the vaults of the Central Bank for the interest of the Filipino people. to serve as US dollar reserves required by the IMF and the World Banks, while that 5% of, that 1% of the required royalty fee which was unpaid starting in the year 1969 to the present, and to its succeeding years until the precious metals has been withdrawn, based on the prevailing market price should be paid directly to the authorized heir, Prince Julian Morden Tallano. 10. That the government buying prices of the subject land from the Tagean Tallano family should be subjected to the following quotations, hereunder. First, within the Greater Manila area, a residential lot dash at a price of P1000.00 per square meter for a maximum of 10,000 hectares. B. Commercial lot dash P1500 per square meter for a maximum of 5,000 hectares. Page 121. Second, for the provinces of Rizal, Laguna, Cavite, Batangas, and Bulacan, a residential lot dash P100.00 per square meter for a maximum of 10,000 hectares. B. Commercial lot dash P2000 per square meter for a maximum of 10,000 hectares. C. Agricultural land dash P10.00 per square meter for a maximum of 500,000 hectares. Third, for the provinces in central Luzon including Pangasinan, a residential lot dash P70.00 per square meter for a maximum of 50,000 hectares. B. Commercial lot dash P1500 per square meter for a maximum of 10,000 hectares. C. Agricultural land dash P5.00 per square meter for a maximum of 500,000 hectares. Fourth, for the provinces of Ilocos region including La Union, a residential lot dash P70.00 per square meter for a maximum of 10,000 hectares. B. Commercial lot dash P1200 per square meter for a maximum of 10,000 hectares. C. Agricultural land dash P5.00 per square meter for a maximum land area of 500,000 hectares per province. Page 122. Fifth, for the provinces of Mountain Province region including Kalinga, Ifugao and Nueva Vizcaya, a residential lot dash at a price of P30.00 per square meter for a maximum of 10,000 hectares for the whole region. B. Commercial lot dash P1000 per square meter for a maximum of 10,000 hectares. C. Agricultural land dash at a price of P3.00 per square meter for a maximum of 50,000 hectares per province. D. Baguio City, a residential dash at a price of P100.00 per square meter for a maximum of 2,000 hectares. B. Commercial lot dash at a price of P1000 per square meter for a maximum of 10,000 hectares. Sixth, for the provinces of Northern Luzon region including Isabella, Cagayan and Batanes, a residential lot dash P50.00 per square meter for a maximum of 10,000 hectares. B. Commercial lot dash P750 per square meter for a maximum of 10,000 hectares. C. Agricultural land dash P3.00 per square meter for a maximum of 500,000 hectares. Page 123. 7th, for the provinces of Southern Tagalog, Quezon, Sub-Province of Aurora, Sub-Province of Quirino, a residential lot dash P200.00 per square meter for a maximum of 10,000 hectares. B. Commercial lot dash P1000 per square meter for a maximum of 10,000 hectares. C. Agricultural land dash P3.00 per square meter for a maximum of 200,000 hectares. D. For the province of Mindoro, a commercial lot dash at a price of P700.00 per square meter for a maximum of 10,000 hectares. B. Residential lot dash at a price of P50.00 per square meter for a maximum of 10,000 hectares. C. Agricultural land dash at a price of P3.00 per square meter for a maximum of 300,000 hectares. E. For the province of Bicol and Batangas, a commercial lot dash at a price of P500.00 per square meter for a maximum of 10,000 hectares. B. Residential lot dash at a price of P40.00 per square meter for a maximum of 25,000 Hectares. C. Agricultural land at a price of P3.00 per square meter for a maximum of 300,000 hectares. Page 124. F. For the province of Palawan. A. Commercial lot at a price of P500.00 per square meter for a maximum of 5,000 hectares. B. Residential lot at a price of P50.00 per square meter for a maximum of 5,000 hectares. C. Agricultural land at a price of P2.00 per square meter for a maximum of 200,000 hectares. 8th. For the provinces in Visayas. A. Commercial lot. First class town P1000.00 per square meter. Second class town P700.00 per square meter. Third class town P500.00 per square meter for a maximum of 10,000 hectares. B. Residential lot. First class town P500.00 per square meter. Second class town P200.00 per square meter. Third class town P100.00 per square meter for a maximum of 200,000 hectares. C. Agricultural land at a price of P5.00 per square meter for a maximum of 300,000 hectares. Page 125. 11. And that petition of the Republic of the Philippines for a conveyance and quieting / and for annulment of all the titles that has been issued from owner certificate of title number 01 to OCT 100,000, particularly these OCT number 2573, OCT 291, OCT 160, OCT 994, OCT 547, OCT 632, OCT 498, OCT 529, OCT 393, OCT 339, OCT 333, OCT 360, OCT 614, OCT 543, OCT 448, OCT 408, OCT 409, OCT 414, OCT 222, OCT 466, OCT 779, OCT 540, OCT 777, OCT 746, OCT 4085, OCT 730, OCT 735, OCT 4136, OCT 280, OCT 844, OCT 331, OCT 374, OCT 0-14, OCT 111, OCT 085, OCT number 2 up to OCT 100,000, and including OCT 820, which are considered and declared null and void ab initio, and cancelled in toto from the beginning, has been granted. 12. Ordering the Honorable Register of Deeds of the place where the said land titles and OCT had been issued to cancel the same, and the subject land covered therein by these original certificate of titles should be reconveyed, and be transferred to and in favor of Prince Lacan Acuna Tallano Tagean or to his successor in interest, Prince Julian Morden Tallano. 13. Thereby ordering the Honorable Register of Deeds of the Province of Bulacan and or Manila, Honorable Register of Deeds of Caloocan, Honorable Register of Deeds of Rizal, Honorable Register of Deeds of Pasay, Honorable Register of Deeds Makati, Honorable Register of Deeds of Batangas, Honorable Register of Deeds of Cavite, Honorable Register of Deeds of Laguna, and Honorable Register of Deeds of the Towns, Cities and Page 126. Municipalities in Luzon, Bicol, Palawan, Mindoro, Visayas and Mindanao to reconvey the lands that have been covered by OCT number 01-4 in the name of Don Hermogenes R. Rodriguez to and in favor of Prince Lacan Acuna Tallano Tagean and the lost original and owner's duplicate copies of the said reconstituted OCT number 01-4. Should be issued to and in favor of Prince Lacan Acuna Tallano Tagean married to Princess Raulina Maria Elizabeth Overbeck Macleod, and or to his successor in interest, Prince Julian Morden Tallano, single, Filipino, a resident of number 654, Marian Avenue, Villa Gloria Subdivision, Angel City, Philippines. 14. Ordering both Bureau of Land and its Survey Division to reconstruct and/or restore all relevant documents, records, microfilm and corresponding Plan PSU 2031 and Plan the Second 69 to and in favor of said Prince Lacan Acuna Tagean Tallano or for, and in the name of his successor in interest, Prince Julian Morden Tallano. 15. Ordering the Honorable Register of Deeds of Manila, Cavite, Laguna, Pasay and of the province of Rizal in Pasig to segregate the land covered by TCT number T-408 under the Plan PSSU 2031 containing an area of 125,326 hectares for, and in the name of Don Gregorio Madrigal Acop. 16. Ordering the Honorable Register of Deeds of Bulacan to segregate the land area of 271,276 hectares covered by said TCT number T-498, which was being neglected to segregate. Page 127. From said OCT number T-01-4 from mother title OCT number T-01-4 should be segregated, and its corresponding TCT be issued in favor of the following persons. A. That the land in Taguig including land area in Fort William McKinley consisting of 2,212 hectares more or less, for a total of 3,370 hectares should be segregated, and that corresponding TCT should be issued to and in favor of Prince Julian Morden Tallano. B. That around 300 hectares from Fort William McKinley, part, and portion of 2,212 hectares, should be segregated, and its title be issued to and in favor of the late Sir Villano Acuna from its TCT number T-408 of its derivative OCT number T-01-4, or to his Senator Benigno Aquino who divulged the evilness of the LRC and the Bureau of Lands. C. That around 300 hectares from Taguig should be segregated, and its corresponding TCT should be issued to and in favor of the heir of said Siargong Tabak, his realers Don Santiago Taguig Almodura who defended the area of Taguig, Paranaki, and Las Pinas against Spanish soldiers, from its TCT number T-408 of its derivative OCT number T-01-4. D. That around 400 hectares portion of 2,212 hectares of the Fort William McKinley should be segregated, and its corresponding transfer certificate of title from TCT number T-408 of its derivative OCT number T-01-4 be issued to the beneficiaries and heirs of the World War II, Korean War and South Vietnam War veterans. Page 128. E. That as part of consideration of the heirs of the true owner to all lawyers of the Integrated Bar of the Philippines who continuously fighting against this despotic government supporting the true essence of justice under democracy, an area around 200 hectares. Portion of Fort McKinley should be segregated, and its corresponding TCT should be issued to the Integrated Bar of the Philippines. Its benefits should be for its officers and members who are determined to fight for justice under the tenet of genuine democracy. F. That an area of 1,200 hectares in Bacoor, Cavite should be segregated, and its corresponding TCT from TCT number T-408 of its derivative OCT number T-01-4 should be issued to the cousin of Don Esteban Benitez Tallano, certain Leonora Rojas who is married to Don Feliciano Cuvas of Bacoor, Cavite. G. That an area of 3,640 hectares in San Juan del Monte and Mandaluyong should be segregated, and its corresponding TCT from TCT number T-408 of its derivative OCT number T-01-4 be issued to and in the name of the late Don Juan Ejército and or to his successor in interest, the couple of Engineer Emilio Ejército and Mary Marcelo Ejército of San Juan, Greater Manila area. H. That an area of 2,000 hectares in K.O.R.A.N. Bulacan and its corresponding TCT from TCT number T-408 be issued to and in favor of Doña Mary Marcelo Ejército as a gift her grandfather-in-law, Don Juan Ejército, for consideration as most outstanding sanitary engineer of the Marikina Valley Mining Company in the year 1916 to page 129, 1936, for his noble contribution and heroism who totally stopped the supposed flash floods that saved the lives of 200,000 people in the city of Manila and its suburbs from the said mining dam during the heavy rain in the year 1921. I. That an area of 271,276 hectares evidenced by TCT number T-498 be segregated from OCT number T-01-4 for the segregation of an area of 340 hectares which was corrected from 1,340 hectares in Malabanan. Another 600 hectares likewise corrected from 1,600 hectares in Navitas for a total of 940 hectares should be segregated, and its corresponding title from this derivative title TCT number T-498 should be issued to and in favor of Don Francisco Masolo, who served as financier of the clan, or to his successor in interest, J. That an area of 300 hectares in Bilibid Vijo, San Miguel, Quiapo, Manila portion of TCT number T-408 from OCT number T-01-4 be segregated, and be issued its corresponding title to and in favor of attorney Benito Ligada and his heirs or assigns who served the royal family as legal counsel of the estate, K. That an area of 7.4 hectares situated Mayasukat Road situated in Beriosto, Nino, Paranaki, Wrestle where the ongoing construction of this proposed government building be segregated, and its corresponding TCT be issued from TCT number T-408 its derivative OCT number T-01-4 to and in favor of Prince Julian Morden Tallano or his successor in interest. Page 130, L. Ordering the Honorable Register of Deeds of Quezon City and or Bulacan to segregate an area of 50 hectares portion of 271,276 hectares of TCT 498 and its corresponding land title be issued to the Iglesia Ni Cristo embracing the INC Central to prevent from any further land dispute in the future. M. Ordering the national government and the local government of the de Angus and or General Santos town to reconvey some 750 hectares of commercial lot within town proper of said town. 17. Ordering the national government, its agencies and instrumentalities, including the Department of Justice and its Honorable Solicitor General to respect the imprescriptibility clause of this decision with compromise agreement against 5 years prescription period of execution for the new issuance of the lost original and owner's duplicate copies of the reconstituted OCT number 01-4 and its expedience transfer certificate of title number T-408 and TCT number T-498, if ever these two TCT have been reconstituted, considering that the issuance of reconstituted copies of subject OCT and its TCT number T-408 and TCT number T-498 are indispensable in the availability of funds for the payment of taxes, which, the sources of said funds have been sourced directly from the P3 billion pesos and its interest of 7 and per annum for 30 years ending on December 31st, 1998 to be paid by the national government as accumulated damages to the Tallano Tagean clans over the estate as one among the conditions specified in this decision with compromise. Page 131, Agreement. While the payment of the government to the clan originated in the year 1961 with 10 years grace period ending December 31st, 1971 with an interest of 7% per annum. But to no avail as part of this stipulation said payment has been extended for another 28 years ending December 31st, 1998 where partial payment of P2 billion pesos in the form of land bank bond certificate dated 1968 for another 30 years moratorium had attained also ending December 31, 1998. Clearly, the payments of the national government will be started on January 1st, 1999 where the reckoning date for the 5 years prescription should be on the same date, January 1st, 1999, provided the government will observe religiously its payment, that as well as no prescription period on the part of the estate to collect said payment of damages from the government. 18. Ordering the National Treasury or its depository bank, Philippine National Bank, Land Bank of the Philippines or the Prudential Bank, to release the P1 billion in cash, which is due and demandable to date to the Tagean Tallano clan represented by its heir Prince Julian Morden Tallano, as part of the damages sustained by the family over their lands and their crops from million of mango fruit-bearing trees and other orchard plants bulldozed and destroyed by the Department of Public Works and Highways, and by their cohorts real estate developers. Page 132, 19. ordering the national government, the Department of Agriculture and its succeeding concerned government agency to waive, reconvey and transfer its possession including its corresponding title when available over the 4 lots and the whole Crisostomo estate consisting of 3,735 hectares in Cabanatuan and Santa Rosa to and in favor of the late Prince Lacan Acuna Tagean, or to his successor in interest, Prince Julian Morden Tallano, or to his heirs or assigns. 20. Ordering the other government agency and the Bureau of Lands in Baguio City including the city government of Baguio to assist the landowner to recover their land in Green Valley and their land in Stowe Point Thomas, Bengoot which is under the unlawful detainer of certain Vicente de Wang, the farm helper, certain Gregorio Quesabeng, the tenant of the landowner, consisting of 500 hectares of raw land, including some 3,700 hectares in Camp John Hay to facilitate segregation and its corresponding land title be issued to and in the name of late Mattia Quirino or his heirs for an area of 700 hectares. 21. Ordering all authorities, the member of Integrated National Police, the member of PC, the member of Philippine Army, member of Marine Force and the member of the National Bureau of Investigation, and authorities form part of the AFP the sheriff of the town/cities and officials of barrio government units where the lands are located to respect this decision, and extend assistance to the landowner or their legal counsel toward relocation. Page 133, and recovery and fencing of the subject lands within your localities. 22. Ordering the national government, its concern agencies, the Bureau of Land, the Land Registration Commission assigned in Mindanao including the Honorable Register of Deeds of the areas where the lands are situated covering the whole area from of Cotabato, Jalo and Sulu to segregate said area from its mother plan the second 69, and its corresponding TCT, its derivative land title is OCT 01-4, be issued to and in the name of with the word Muslim Brothers and Sisters of Mindanao, to stop civil war in the Mindanao area which is the root cause of that strife, where such ancestral lands as legacy of the King Luisang Tagean Tallano have been abused, but now it be instituted, exercised, and implemented without delay in favor of his Muslim descendants. 23. Ordering the Honorable Register of Deeds of the Province of Rizal in Pasig and or Makati, including Honorable Register of Deeds of the City of Manila and Honorable Register of Deeds of the Province of Nueva Ecija in Cabanatuan to reconvey, transfer the following lands, here namely to and in the name of Prince Lacan Acuna Tagean Tallano, or to his heir Prince Julian Morden Tallano, A. For the City of Manila, land under CLRO, Cadastral Record 302, from Expedient Cadastral Number 62 under Certificado de Titulo de Transferencia number 26727, CLRO Record. Page 134, number 786 in the name of Benito Manitoc Lerma, under lot number 60, block number 2918, of an area of 31,567 square meters and 70 square decimeter, lot number 62 of CLO record number 786. Also in the name of Benito Manitoc Lerma with an area 49,300 square meters and 1010 square decimeters, lot number 68, CLRO 786 also in the name of Benito Manitoc Lerma with an area of 1,957.30 square meters. More or less, lot under CAD. Number 13 containing an area 30,000 square meters, more or less, B, for the province of Rizal in Pasig and or in Makati situated in Taguig, Paranaque and Pasay City, all lots under expedient number 2484 in the name of Doña Dalo Ruiz y Quezal also in the name of Hacienda Miracaban under decree number 1368 containing an area of 25,743,514.75 square meters, more or less or 2,574 hectares and 3,514.75 square meters previously under civil case number 119 of the CFR of Quezon City. Page 135, 24. Ordering the Honorable Register of Deeds of K.O.R.A.N City to reconvey the land with an area of 4,399.32 square meters, more or less under alleged plan the 2nd 4816, which was previously under civil case number 119 of the CFI of K.O.R.A.N City, allegedly evidenced by OCT number 362. By virtue of this decision with compromise agreement, which the claimant for this land was barred by statute of limitation, and of compromise agreement and the corresponding land title be issued to and in favor of Don Esteban Benitez Tallano or his heir Prince Julian Morden Tallano, 25, lot along and situated in the capital site and Fairview Avenue, and North Aqueduct bounded on the east by Commonwealth Avenue, on the south by Republic Avenue and the proposed BF Homes housing projects, and of Sitio Commonwealth, Barangay Diliman of then Caloocan City, now K.O.R.A.N City, containing an area of 1,205 hectares and 3,000 square meters, 26, ordering the Honorable Register of Deeds in Nueva Ecija in Cabanatuan City to reconvey the Crisostomo estate under Decree number 347,312, under Plan the 2nd 11,288, and lots situated in Barrio Bagnoy, Barrio Soledad Municipality of Santa Rosa, containing an area of 131.79 hectares, and another lot, Lot 2, Lot 3, under Plan the 2nd 11,288, situated in Gregorio Crisostomo and Vitas in Cabanatuan City, containing an area of 3,250 hectares, and another lot, Lot number 4 of Plan the 2nd 11,288, situated in Barrio San Gregorio, Santa Rosa, Nueva Ecija, with an area of 1,217 hectares, more or less, and its corresponding TCT also be issued to and in favor. Page 136, of Don Esteban Benitez Tallano or his heir Prince Julian Morden Tallano, allocating therefrom an area of 100 hectares from lot number 2, and be segregated, and its corresponding TCT be issued to the compadre of Mr. Benito Tallano, the incumbent Governor Eduardo Johnson or his heirs, 27, ordering the Honorable Register of Deeds of Wrestle in passing to reconvey and its corresponding title TCT of land with an area of 32,322 hectares, more or less, be issued to Don Gregorio Madrigal Acop and his heir Julian Morden Tallano under an alleged TCT number 8037 in the name of Fortunato Santiago, married to Maria Pantanilla Santiago, 28, ordering the Honorable Register of Deeds of the City of Manila to cancel OCT number 8349 under special patent number 969, and its subsequent TCT that was issued in the name of Land Bank recently. Said TCT number 101,002 on May 5, 1970, which was null and void ab initio, including its title thereto, which was barred by the decision with compromise agreement, and said land under said barred OCT 8349, TCT number 101,002. And its subsequent land title should be reconveyed and its corresponding land title be issued to and in favor of Don Madrigal Acop, or to his assigned heir, Prince Julian Morden Tallano, considering that the same subject land under LRC/civil case number 3957P, where the other claimant, Fortunato Santiago, married to Maria Pantanilla Santiago, who presented said document under Plan the 2nd 69, Lot 1, and Lot 2, had never succeeded under this proceedings by reason of page 137, prius tempori portia jury, and by reason of that null and void ab initio, no force and effect. 29. Defiance to this decision by anybody, a corresponding arrest and imprisonment should be enforced by virtue of the contempt of court, and stiffer penalties should be charged. 30. That the only authorized executor over deed of absolute sale, conveyance, deed of donations, contract to sell involving the estate is the lawful successor in interest of Don Esteban Benitez Tallano, Don Gregorio Madrigal Acop, and Benito A. Tallano in the person of Prince Julian Morden Tallano, provided the consideration should not be lower than the 30% of the prevailing market value, its initial required down payment, if any there be. In the absence of 100% cash down payment, consideration should not be lower than the 10% of the 30% of the prevailing market value. However, in the absence of the herein specified lawful heirs, his eligible wife, qualified to suit the requirements set forth by his predecessor, Don Esteban Benitez Tallano, who used to be a graduate of a 4-year course, passed the professional regulatory or any government board examination, born under the zodiac sign of either Scorpio, Sagittarius, Capricorn or Gemini, whose name should be identical to late Princess Rowena Maria Elizabeth Overbeck. Macleod, whose mentality is highly positive with exerted efforts of cooperation and determination for the estate, and her characteristics is with high turpitude free of untainted chastity being a Page 138, genuine maiden lady, who earned by the order of this court the similar title of princess, to serve as with the noble title with true love, and worthy services for the prince or any of his children, provided their lawful ages should have no less than 24 years of age, that the only authorized land area, to deal for said deeds should not be in excess of 10,000 hectares at 70% to his principal and 30, and for the estate which must be applicable to every person, juridical or natural person. That any special power of attorney, general power of attorney, deed of assignment with conveyance or authority that has sale, mortgage or reassignment clause, is hereby declared null and void, no force and effect, and barred ab initio. Any provision, agreement, contract, or stipulation to the contrary, such deeds of whatsoever nature the same has been treated null and void, no force and effect ab initio, and nullified forever. Let this decision with compromise agreement be enforced enjoining all concerned private persons and government authorities herein specified and every body, natural or juridical person, to observe and address this decision with compromise agreement observing the imprescriptibility period clause over its execution or issuance of its required original and duplicate copies of OCT 01-4 including its TCT number T408 and TCT number T498 an. Page 139, including the withdrawal of the deposited gold bullion from any government body, within and or outside the archipelago, either a member of United Nations or any League of Foreign Nations, federations as long as within the bond and jurisdiction of the International Court of Justice to serve for the interest of the lawful beneficiaries of late Prince Julian Macleod Tallano and the whole Filipino people in general. Otherwise, anyone who defies this order shall be dealt accordingly with the fullest force of the law. So ordered, Pasay City, February 4th, 1972. Signed, Enrique Agana, Presiding Judge.